The interim order, extension of interim order will be expiring on Friday, Lordship. It is an assigned matter before your Lordship.
Tomorrow.
Grateful, Lordship.
Tomorrow.
May permit to mention, my lord, granted leave, my lord, for without certified copy, my lord.
Why without? What is the urgency? Why you can't wait?
My lord, already 24th June already I applied for the certificate.
Why you can't wait? That we are asking.
This is industrial tribunal matter, my lord, and 45 days time, my lord. Already 30 days already gone, my lord.
What?
All for filing, my lord. Already 30 days already gone, and not for 10 days already. Yes, my lord.
You file it with the certified copy.
Mr. Lordship, I'm mentioning with respect of that matter where there are two properties, terrace flat 93. Yes, Your Lordship, the matter was fixed on 30th for hearing of Your Lordship respondent number 1. Now, with the consent of the other side, Your Lordship, the appellant, we have realized that on 30th, both the senior counsels of the parties would be occupied in another Birla matter, Your Lordship. So, with the consent of the other side, Your Lordship, I'm asking just to adjourn on that date. We will be appearing on 31st and initiating our argument.
So how we can adjourn it today?
Not today, Your Lordship. It can be kept on to be mentioned or when.
Why? It will come on 30th to mention that day. It's good you have informed the court. You mention also.
Great.
Item number 1.
Lord, I am for the petitioner, Lordship. This is my evidence of status. Lord, fact is that the petitioner was the police driver of the Calcutta police, Lord. I am challenging the dismissal order as well as the appellate authority's order. Can you see the dismissal order on the ordering portion, page 108?
It will be adjourned.
So what is your point?
My point is that whatever incident was happened now, it is not so serious, but the authority, considering that incident, dismissed me from my service. But when the fact is that, kindly see the charge sheet, page 57. What is the charge, Lord? Here, place it, Lord. You police driver, such and such, South Division, Kolkata, is charged with gross negligence in performing government duty and becoming a member of Kolkata Police Force in that. On 4th December 2023, you were assigned to perform duty at mobile toilet van registration number such and such station in front of 188 Police Mukherjee Road, Kolkata 26.
Where is your license?
Not license was there, but license.
So where is it? Show us.
License was not renewed. That's true. License was not renewed because I was under the direction of the department.
So without license, you are a police driver and you are suppressing this from your employer.
Not suppress. Not.
And if they have dismissed you, say you say it is not that big a mistake.
No, kindly see.
Anybody can't drive without license.
Allow me, Lord, will praise
Yes.
the facts, Lord. Then
No, this is the fact. There is only two facts. One is you have knocked down the guardrail. Instead of moving it forward, you have reversed the vehicle.
Inquiry officer did not at all consider.
Forget inquiry officer. Therefore, we are saying, where is your license?
I have already admitted that it is an intentional mistake now. Because
So, driving without a license in police service is a mistake and it should be condemned.
I don't know, but
And it should be condemned.
Kindly allow me, my lord. Please, my lord.
Yes.
Facts, my lord.
This is the fact. There is no other fact.
The fact is not that they have not narrated on that score, my lord. They have determined to punish me because I was not duty of the driver, police driver, because I was seriously ill, as well as the SSKM hospital. It is known authority. The number of occasions they have admitted. They did not allocate any duty.
They did not.
Yes,
They did not.
authority did not allocate any duty for driving. On that day, 4th December 2003, authority assigned my duty to supervise the two mobile toilet van which was parked in front of the MP Abhishek Banerjee. That is on that day from 8 to 6 p.m. On that day, I was there, and the driver was also there. At 10 p.m., the driver take me permission that I shall go to the take dinner. Please follow me. Please see the situation. So my driver left. That motor toilet van was parked. That is in front of the KMC workers' residence block. They agitate in different way because due to bad smell. And I tried to specify the situation, but they did not at all hear me. Then, Lord, because I know very well this is a jet category area, to specify the situation, Lord, I just relocate the vehicle from that side to another place. On that position, Lord, because due to because long ago I did not use that driving, and due to mistake, Lord, was used from left gear to that, which he admitted. On that basis, that's the guardrail, and thereafter it was just knocked the door. I have already basis the charge has been issued. It was not my intention to damage or destroy anything. And then
We didn't say anything. We only said, can you drive without license? Forget about your intention. It was mistake. You
that basis,
then how you are driving.
not
So therefore, you should be dismissed. In a police service, you are driving without a license.
I have not drive, just relocate from that area to kindly see the report, Lord.
That was your duty to drive that vehicle that day. You should have.
Not only to supervise. Only to
Where is the duty assignment?
duty assignment name. Name. Yes, But I am placing the report of the. I am placing the report on regarding the charge.
Of?
Placing the report of the findings of the report of the inquiry officer, from which it will appear that I was allocated only to supervise the toilet van. Because there was a driver also, that is Vola. In the name of, subsequently I came to know his name was Vola. My intention was not at all to drive the vehicle, because the situation, can you see the report of the DC traffic, but the inquiry officer did not at all consider. Can you, I am placing that report, can you see? 94. 50? 94, 94. Report. DC traffic. 91. The 91, which has been quoted, I have already narrated to my petition, Lord. Page 8, page 8. Page 34, Lord. My specific submission before your lordships, that the inquiry officer failed to consider report submitted by Joint CP Training, Kolkata Police Training Academy, dated 6 December 2023. From the report, it appears that it has been reported that after receiving information of an incident over telephone by learned CP sir, rushed to the spot, and on reaching came to know that a mobile toilet van had been stationed along the Horish Mukherjee Road near the residence of MP Abhishek as usual. On complaint, local residents, can you see? On complaint, local residents about the bad odors from the vehicle, the driver tried to relocate it. I had no intention to drive the vehicle. I tried to relocate it. However, while he was trying to turn back, the vehicle lost control, and all on a sudden, the back of the vehicle dashed against the entrance of the residence Shantiniketan of MP Abhishek Banerjee, situated such and such, resulting partial damage of both the vehicle of the entrance gate. On that basis, I have already apologized that. Yes, it has been mistake on my part, but I had no intention to damage the property as well as the MP's residence also. So, my lord, merely simple offense. On that basis, my lord, dismissal. I am asking myself. Offense is so serious, my lord. That so harsh punishment has been imposed. I am the sick person. I am only medical expenses. I have to bear everything. But they have already terminated me from my service. Well, there is a minor of penalties there. They can impose a minor penalty when I have admitted my guilt, my lord. Dismissal, my lord. Whether is it commensurate with the punishment, the offense commensurate with the punishment. I am repeatedly stated, even not only that report, also that I had no intention to drive the vehicle because there was a commotion to specify the situation because I know very well that is a debt category area.
When you intimated them that your license is not renewed, where is that intimation? Your intention will appear only from that if you have intimated.
License has not been renewed.
Since when?
Doctor's report, madam.
Since when not renewed and when you intimated? That will reveal your intention.
I have already annexed the documents, not medical report. And thereafter, my license has not been renewed. Kindly see the medical examination, that is page 50.
Anywhere you have stated since when your license is not renewed.
I have not mentioned the date.
Why? You don't know.
Authority known that.
Why you have not mentioned? Because you are talking of intention, therefore we are asking these questions. We have to gather your intention from the case papers only. We can't just gather the intention from your submissions.
2000.
You are claiming that you are sick since long your license has not been renewed. This is admitted position. You say since long. Still you don't mention since when, whether prior to getting the appointment, after getting the appointment.
Can you see the 2015 page 52 medical report?
Huh?
2015. 2015, my lord.
2015.
50. That is medical report. Hospital advice the authority to allocate a life duty. So since then, my lord, not allocated any driving duty. So I am the police driver.
No, this is not your case. That since you have not been, since then you have not been allocated driving duty. It is your case that since then you have not been allocated heavy vehicle duty.
Well, I have admitted because the situation is so serious. That's
Such
why
a person in a police force, such a person for 9 years without driving license is carrying on his job.
No. That is authority known very well. That's why they have allocated.
So we ask you, where you have intimated them that you said that they are knowing very well.
It's 55 well.
Yeah, 55. The Deputy Commissioner of Police, illness plot.
Deputy Commissioner,
That is nothing.
page 55, my lord. Can you see? Deputy Commissioner of Police sent a note, my lord, that is driver Dhirendranath Mahato, since posted to headquarters, is allowed to join up such and such, and ordered to give light duty in continuation of direction standing medical board government of West Bengal, that is 14 March 2007. He is sympathetic and cannot perform duly police driver and also be allowed to perform some other light job. That's why they authority never allotted page 55A. Thereafter, authority never allotted any driving duty to me. On that day, they have allowed to me to only the supervise the situation.
And
whether
order to, what is it? How you can read? We don't know. We can't see.
55A block.
Light duty.
Type copies. So, the question of the suppression does not arise at all because authority knows very well. That's why they never allocated.
Sense.
That is the
Suppression is why you have not informed them that you don't have a license. Again and again, we are asking you when you have informed them that you don't have a license.
so authority.
And since when you don't have a license? Nobody knows that you do not have a license.
No, my lord, can you allow me, my lord? I am placing that facts. Inquiry officer finding also that. Please, thank you, Puna. Lord, kindly see the page 95, Lord.
They can presume that he doesn't have license.
Lord, kindly see the page 95, Lord.
Which page?
Page 95.
95.
95, Lord. From bottom to third paragraph. That in the report which was submitted by Sri Shantanu Chattopadhyay, it was ascertained that CODN Mahato was assigned only to look after the vehicle toilet van, as the CO was recommended for light duty by the medical board. As such, he was booked only to look after the vehicle. So, my lord, that's why it is known within them that thereafter license has not been renewed, not has been cancelled, because I was not allotted any duty, my lord.
We don't know the bona fide of this stand because you have suppressed the information since when your license is not valid.
Authority known, that's
Bona fide of your stand is not apparent.
known very well. That's
Nobody knows about your license. Again, we are asking you show from any document that you have told them that I don't have a valid license.
yes, I am
You
coming.
are a police person.
I'm coming for the.
You're not an ordinary individual.
I'm coming, Lord. The
You file an opposition. We'll see. File
document,
an
My
opposition.
lord, may I submit, my lord?
No, we'll hear you after the opposition. When your commissioner has held that he cannot be assigned such driving duty, then why he has not been given an alternative job?
My lord, he was.
No, he was not.
My lord, may I allow me to submit, my lord? He was given a duty to supervise the toilet van. He on his own went on to drive that vehicle, to relocate the vehicle. My lord, this is a complete dereliction of.
Duty assignment was brought before the inquiry officer.
It was brought before the
Where
inquiry.
is that? Show us.
My lord, we'll see in page 94, my lord.
94. It is which exhibit? The duty assignment?
My lord, that exhibit has not been there, my lord.
Then how it can be
It
considered?
is an admitted fact, my lord, that he was assigned to look after the toilet van. It is his admission, my lord.
What do you mean look after?
My lord, look
He
after.
will not perform duty of a janitor.
My lord,
He is a driver.
he is a.
There is a van, but there is a van. You have given him a duty on the van. Supervise means what?
Kindly appreciates. For a long time, my lord, he has been given a light duty because on medical ground he is not allowed to drive the vehicles. This is a admitted fact, my lord.
Exactly. So what is there? Therefore, we are saying what was his duty?
On the said date, my lord, his duty
What
was.
was his duty? Don't make submission. Show. What was his duty?
My lord, then I'll come back.
Therefore, we are saying file your opposition. Let affidavit in opposition be filed.
August.
I'm grateful.
Item number 2 and 3.
May we please your lordship, my lord? Is that matrimonial matter, my lord, where the parties have decided?
We were informed
My lord,
that there is a resolution.
Yes, yes.
No.
So we have already, my lord, drafted a terms of settlement, which was agreed by and between the parties, my lord. Now the problem is, my lord, because it was a 1 week gap, my lord, I couldn't comply it with the petitioner as well.
How much time you need?
My lord, maybe 1 week or 2 weeks, as your lordship please.
Don't say maybe, give us a time now.
My lord, subject to their convenience, my lord, because I have drafted it, it's ready from my end.
How much,
Now, just that I have to give it to them.
how much time? you-
My lord, let it, for the timing, my lord, let it go out of list, my lord, the matter, with liberty to mention. Then, my lord, at least 2 weeks, my lord.
Don't prolong the issue unnecessarily.
Exactly.
That is not appreciated. The time granted earlier.
Item number 48. So, Lordship, my lord, I will take the-
To 8, my lord. Mrs. Chandri Alam is ill, my lord, so I am praying for not this week, my lord.
My lord, in the submission, there was a direction for signed copy.
So I have such a copy.
No.
Off.
My lord,
Oh,
but it is supplied to the
that regulation or something.
regulation, yes, my lord. It is supplied.
We are informed that the London GP is
Passed by the Honorable Supreme Court of India on 1st of June 2026, my lord. I am relying upon, may I serve a copy and file this?
give us, you can give on that day also, as you like. Whenever you give, we will have to consider. Whether you give today or you give on
Yes, my
that.
lord. This is made ready, my lord. Kindly allow me to.
Okay, you can place it on record if you want. Yes.
It are together. I'm serving one copy, my lord. It is-
With judgment, party's name?
My lord, Bhikani Devi and others, my lord. Union of India. Initially, the tribunal of Patna, my lord, that has been considered. Thereafter, the High Court, Patna High Court, disagreed and went to Supreme Court. Supreme Court allowed. But I am relying on the principle of the judgment. Well, let it be considered, my lord.
Yes. Yes. Put it in the file. Don't misplace it.
August. Item number 9. I know I have care for the traditional. I can put the order to the line. So no matter. Order.
When you were extended the benefit of memorandum dated 16/9/11,
That was for. That was not, that is under judgment.
16/9/11 was also not made. Or only 25 to 2016 was not done. Both. Then why the tribunal has recorded the mere fact that some benefit were given earlier under notification of 9008 does not confer any right to claim benefit under what 1107.
Under some.
So what benefit was given under 9008? No benefit. Please see second page of the tribunal's order.
My lord.
Last sentence of the second line. Third page, not second. Third page. Mere fact that some benefits were given. Third page, second paragraph, last sentence. So you are given some benefits under 9008 or you are not given benefit?
That's not.
Yes.
My lord, only issues, my lord, whether I am on a sanction post or not. Tribunal may issues, my lord, the post was not sanctioned.
No, plus continuity is also an issue. There are two issues.
Fine.
One is whether it was against a sanction post
Fine.
by competent authority. Second is the continuity, whether you qualify under 16/9/2011.
Yes, madam, continue. That I qualify, madam.
Because your admitted case is that you started in 2006.
My lord, that was.
That is, there is no dispute on that.
For 2000,
So when you started in 2006,
my lord.
how it can be said in 2011 that you have been working for 10 years? And unless you are working for 10 years in 2011, the cascading effect of the subsequent memorandum cannot be made available to you. It is not for new persons. All that is for the persons who were already granted benefit under the 9008. 1107 at page 62 does not contemplate grant of benefit to one who was not a beneficiary under 9008. 9008, admittedly, you hardly had 5 years of service. There is no question of having 10 years of continuous service. How you can get the benefit? What is your case? You may argue.
My case is, my lord, I was engaged attending the OT in 2006. There is no dispute.
See, come to page 59,
My lord.
clause I, small I,
The casual daily rated contractual workers who have rendered 10 years of service.
10 years.
10 years.
There is no question by any stretch of imagination. Even if you were against a sanction post, you could not have 10 years in 2011.
40 days attended each year, engaged in the same status.
So now, if you are not covered by this, can you get benefit of 9008? Come to page 62. This is in continuation of 9008.
Right.
For opening line says, in this department number so and so.
So, it was decided to allow appropriate emoluments, security of tenure.
And this talks of improving the monthly remuneration, not including new persons. Clause 2, the matter regarding improvement of monthly remuneration and annual income. So unless you get, how you can get a benefit of improvement?
The matter regarding improvement of monthly remuneration, annual fees, medical facility, leave and other benefits, as well as review of the condition of engagement are under active concern of the government. And after careful consideration of the matter, the government is pleased to decide to review that our contractual railway workers shall continue to be engaged up to the age of 60 years. Engagement contractual casual daily worker shall not be terminated except prescribed in the present. The consolidated monthly remuneration contractual of such. That was it.
Nowhere it says for including anyone who was not beneficiary under 9008. You are still continuing. You are still continuing.
No, just now retired.
Over. You have been you are no longer serving them.
No longer service. Just retired. 2 weeks. কবে রিটায়ার করবে? No,
You crossed the age of superannuation. When?
June this year.
This month. What can be done? Yes.
Lordship, I'm appearing on behalf of the state respondent led by Ms. Shushmita Shahadatul. Lordship, I have not received the copy of the MET, Lordship.
Not required. How do you make out your case? There is no way. Nothing can be done. It is the petitioner's
Item number 10 and 11.
10 and 11, my lord. But I'm suffering, I'm sorry, it's a purely hearing matter. But everything has to be gone into. But can it be after 2-3 weeks, my lord, so they can recoup and come back, my lord?
My lord, 10 and 11, my lord, I am
As prayed
for not
by item 12.
My lord, in this matter, I appear on behalf of the state, my lord. Last time, your lordship has directed me to file the affidavit. It has been signed and been getting affirmed, my lord. It's getting affirmed.
You are filing it today.
Well, I'll try by.
It is stated by the one week after tomorrow. 1 week after tomorrow. पहले 6th दिए थे 6th
6th, my lord. 6th is not Thursday, my lord. Then what's better Friday, my lord? Let that be on Friday.
7th.
But
Thursday is not a good day.
it's an old method, day, my lord. Once method taken up, it takes time, my lord. All the days are good day, my lord. Thursday is really good day. My lord. I'm taking
Item 13.
paying for the petitioners, my lord. There was a. In this matter, I appear on behalf of the state, my lord. I've just received the instruction, my lord. There was the argued direction, my lord, directed me to file a report in form of an affidavit, my lord. The report is with me.
You are filing an opposition.
My lord. I have to prepare.
No, 1 week. 1 week thereafter means 10th. Yes.
Tenth August.
Grateful. In the meantime, you file your reply if you want. 10th August. Item 14. None appears for the parties. You are filing a reply.
But they have not supplied us, my lord, the copy of the, my lord, the eligible documents.
Who is for the state, Mr.
My lord, Gundu Singh, I think.
Guddu Singh.
Guddu Singh. And led by Mr. Lanet GP, my lord. I sent, he told me to send mail. Mail was sent. Then, my lord, he asked me to send by, my lord, WhatsApp. That was also sent.
None appears for the writ petitioner state.
Actually,
Item number 15.
I'm for the petitioner.
Is appearing on behalf of the state. I am praying 2 weeks time because affidavit are complete, but original opposition is not with me and not your lordship file. For that reason, I have to hear from the opposition. Kindly give me 2 weeks time in the meantime.
For this, we have
I have
already,
already supplied them.
we
copy of
already
the
gave you
opposition.
time on 14 July. How much time you need? For reaffirming, you need how much time, madam?
Kindly give me.
By way of last indulgence, we are adjourning the matter. Every case we are finding they are not taking steps. We don't know what to say.
I
It
have
has
already,
become a routine submission on behalf of the state in every case.
I have already made photocopies of the opposition.
I
That
have-
can't be accepted unless it is,
That also we kept.
unless they file it, how it can be kept?
I reaffirm within.
They are not taking steps in any case. State is not taking steps in any case. Very lackadaisical attitude.
Then let this be last chance.
Yes, we have recorded.
In the meantime, I will.
If they don't, we'll proceed without any opposition.
And on
We'll
that day, I
record that they
shall
don't want to
reply.
file.
On
There
that,
has to be a limit. This is going on since May. As if you have all the time in the world. Leisurely. Call the next.
the reply would be filed. Said date.
Instead of vote, kindly take this.
No, that is all. 1 week. If you don't do it, it will not grant any further. Sorry, call the next case.
Item number 16.
Number. Then our presence should be recorded.
Yes, your presence will be recorded.
Yes, my lord, I am for the petitioner, my lord. My lord, on the last occasion, my lord, Lordship, initially the matter came up for the hearing on 7th July. My Lordship was pleased to observe that, my lord, there is a way application has been annexed, my lord. Though certificate copy has been annexed. So today we leave, by leave of this honorable court, my lord, we are filing the supplementary evidence. Supplementary. My lord, this is service, affidavit of service.
You go before the single judge. Same order. Yes. Yes, dismiss with liberty, yes. Instead of disposing of the OA.
Item 17.
None to represent the parties.
Item number 18 and 19.
Please, my lord. This is my appeal, my lord. This is the matter whereby we are processing the qualifications which has been prescribed in the advertisement.
Whether the higher qualification is
Yes.
a disqualification or not. That is
right,
all.
my lord. And whether there is a rule of the bank which prohibits that.
So therefore, whether there is a disqualification or not,
That is right,
the
my lord.
issue.
That is
Yes.
right.
Because it was held that no such provision could be pointed out.
Yes.
Now, where is that provision?
My lord, I had, my lord, when I was, my lord, addressing on the last occasion, handed up, my lord, government, my lord, Ministry of Finance, my lord, circular of 19th of September 2001.
Two things, just first show us the advertisement.
Yes, my lord.
And then show us that provision that you are relying upon.
My lord, kindly comes to the, my lord, page 20 of the, my lord, paper book is the advertisement, my lord. For the type copy, lordship may kindly come to page 77, my lord, of the paper book, my lord. Since it's in Bengali vernacular, my lord, kindly comes to page 77 at page 78. My lord, at page 78, clause B is, my lord, the relevant, my lord, part. Academic qualification, part-time sweeper up to 8th class. Additional educational qualification will not be accepted. For the post of peon, past 8th class, but not past matriculation or equivalent examination. In this case also, additional qualification will not be accepted. My lord, the Bengali, my lord, in Bengali language, the advertisement is at page 20, my lord. Just in case your lordships want to have a look at it, my lord, I can just read it out for your lordships. Just after the table, my lord, at page 20, if your lordships are at page 20, my lord. There is a first entry with the, my lord, serial number K. There is another entry with serial number K, which says in Bengali, Shikkhagoto Joggota.
You are a part-time sweeper or peon?
I am the bank, my lord, peon. First matter is and it says, my lord, in the original, my lord, notice advertisement, peon পদের জন্য অষ্টম শ্রেণী উত্তীর্ণ কিন্তু ম্যাট্রিকুলেশন বা সমতুল পরীক্ষায় অনুত্তীর্ণ, এক্ষেত্রেও অতিরিক্ত শিক্ষাগত যোগ্যতা গ্রহণযোগ্য হবে না, which is basically, my lord, if you are overqualified, then between 8 pass and matriculation, which is 10 pass, it will not be accepted.
So according to you, there was a bar prescribed in
There is a bar prescribed, and this bar is as per the
and this bar is founded on which provision?
My lord, kindly takes, my lord, the rule which I had handed up, my lord. It should be, my lord, in your lordship's records, my lord, a document of Ministry of Finance dated 19 September 2001. My lord, separately, not in the, my lord, supplementary paper book, separately it was given.
Just checking this.
দেখুন এরকম একটা আছে।
It is 13/3/2012.
So, my lord, it's 19 September 2001. Because from the supplementary paper book, lordship had pointed out to me that this is not a rule making power. You have to show me where is the rule. So, my lord, I took instructions from the bank, and thereafter, my lord, we had submitted this document. My lord has found that one. I can hand up my copy, my lord, if lordship, my lord, doesn't have it. Page 4.
What is it?
My lord kindly takes my copy, my lord. My lord, one more copy. Lordship has it.
19/9/2001.
That is right, my lord. This is the Ministry of Finances, my lord, circular to all the chief executives of public sector banks. First paragraph, my lord, kindly, my lord, pardons me, it's slightly highlighted, my lord. I am directed to draw your attention to the announcement made by the Honorable Finance Minister regarding abolition of banking service recruitment boards and provide greater independence to bank management in forming their own recruitment strategy and implementing it. If your lordship turns the page, comes to page 2, my lord, clause 10. The policy should conform to the instructions issued by the government, Reserve Bank of India from time to time on creation of post, filling up of vacancies, staff growth. Copy of the recruitment policy framed by the bank may be sent to the government as and when approved by the board. Then my lord kindly turns the page. The recruitment policy of the concerned bank, UCO Bank, is there. Lordship may kindly come to clause 1.1, the second page of that document, my lord, of that recruitment policy. There has now been a shift in the government policy, and after abolition of banking service recruitment boards, public sector banks are required to frame their own recruitment policy based on guidelines conveyed with the Government of India, Ministry of Finance, letter dated 19 September 2001. This is what I showed. The recruitment policy framed is based on the guidelines mentioned in the aforesaid government letter. Now, Lordship kindly comes to internal page 4, which talks about or which deals with subordinate staff, my lord, recruitment. 5.3 is, my lord, the relevant entry. Subordinate staff, 8 class standard, but loss not less than SSC stroke matriculation. And my lord, considering this recruitment.
But less than, not less than.
But less than, yes. But I'm sorry, my lord, but less than, yes. But less than. So it has to be, my lord, the two pillars are, my lord, 8 class pass, less than matriculation. And basis thereof, this, my lord, policy, my lord, the advertisement was issued because this is, my lord, still in force.
So advertisement is issued by the RM.
The advertisement, my lord, is issued by the zonal manager, ZM. Yes, of UCO Bank zonal office. And my lord, in their, my lord, pleadings which were filed, they have admitted this, my lord, fact that they had higher qualification. If lordship permits me, I can, my lord, draw lordship's attention to that admission, my lord. My lord, in the paper book, lordship will find that at page 64. That starts from page 63, my lord, paragraph 16, the foot of that page, my lord. From the paper book, if your lordship takes paragraph 16 at page 63. Your applicant states that the applicant, against column number 7 of the application form for recruitment to the post of peon, stated that his educational qualification was class 8 pass. In this connection, your applicant states, subsequent to the registration of his name in the district employment exchange in the year 2005, applicant acquired higher educational qualification, but said qualification had not been updated and or recorded with the employment exchange. Since your applicant failed to register his higher qualification with the employment exchange through inadvertence, and since higher qualification is not reflected with the record of employment exchange, your applicant thought it fit to declare his qualification as class 8 pass in the said application. This is, my lord, the justification they give, my lord. And one more document, my lord, to the bank which was given, my lord. If your lordship comes to page 102, this is, my lord, the bank had sought for this information, what was the qualification. In view of the writ petition filed and an order passed, this was sought for, and this is the response at page 102. First paragraph, this is addressed to the zonal manager UCO Bank. This is my humble submission to you that I am a sub-staff of your Rampurhat branch, Mohammad Shahid, employee number such and such. I passed class 8 in the year 2005, and on the basis of that certificate, I have registered my name at Employment Exchange on 7th October 2005. Presently, my educational qualification is BA pass, but except qualification of passing class 8, I did not register any other qualification. Advertisement कब कर? And the advertisement was of 18th of March 2015. So his, my lord, justification which he was trying to give, my lord, is that since my name was registered in the Employment Exchange in 2005 when I was only class 8 pass, in 2015 when I have applied for this post, I did not indicate that I was, by that time I had already
Advertisement dated
18th March 2015.
And he made his application on 5th July.
and he was dismissed.
My lord?
He was dismissed or removed.
Yes, my lord, pursuant to the order of the learned single judge, which got, my lord, stayed by the, my lord, division bench. And thereafter matter travelled all the way up to the Supreme Court, where the Supreme Court, before the Honorable Supreme Court, the bank said that bank could not point out this rule, which permitted the bank to indicate in the advertisement the criteria. And his application pursuant to this 18th March 2015 was made in 2016, my lord, in 2015 itself, 5th of July 2015.
That is
So,
page 94.
my lord, in all earnest, my lord, it was required, my lord, to indicate that he was BA pass, and therefore, my lord, he was otherwise disqualified to even participate.
July 2015.
My lord, 18th March 2015 is the, my lord, advertisement, and his application, which is at page 94, lordship kindly sees 94, my lord.
93 is the original copy, 94 is the translation.
93 is, my lord, the original copy. If your lordship comes to 93 first, my lord, the original copy, again it's in Bengali. The date is at the foot of the page, my lord.
What is the date?
5th July 2015. And in clause 7 or serial 7, Shikkhagoto Yoggota, that is educational qualification, he has, my lord, stated here Ashtom Sreni, which is class 8 pass.
And you are an applicant.
Yes. How's the petition is your lordship? I raised objection before.
You are an applicant in the process. Yes, what do you have to say?
Well, I was carrying one judgment, if lordship.
Yes. His Lordship Justice Datta's judgment.
This is very recent, my lord, of the division bench of Justice Amanullah and Justice Mahadevan, passed in 2026. This is reported in 2026. 2026. Malad just gives me one moment. This is reported in 2026, SCC online, SC 1048. Malad kindly comes to paragraph 3 and 4, Malad. Present appeal is directed against the impugned judgment dated such and such passed by Division Bench of High Court of the Judicature at Madras in so and so, whereby the writ appeal preferred by the appellants came to be dismissed, and the order dated 16th April 25 passed by the learned single judge of the High Court in writ petition number so and so was affirmed. By the said order, the learned single judge had set aside the order of dismissal dated 30th October 2018 passed by the appellants and directed reinstatement of the respondent in service with continuity of
so many copies.
Two copies, Malad.
There are different judgments. No, there are two judgments.
Malad, may I just have, I think I made it stitched all together, Malad. I'll just remove the other one.
No, just see why the other one seems, the first one seems to be very voluminous, the other one seems to be lesser.
No, it can. একটা মোটা একটা পাতলা কেন হচ্ছে? This ends in paragraph 15, which is this.
What is after that? That's what we are wondering.
My lord is correct. Oh, in between, my lord, I think there's another judgment which had inadvertently, my lord, একটু কাঁচি দেবেন। I'll just remove that.
Don't do it in haste, you'll cut yourself.
Yes. One zero four eight up to para 15. একটা আমাকে দে, তোরটা খুলে দে, তোরটা খুলে দে। Well, I was placing paragraph 3 of this, my lord, judgment, then paragraph 4. Counsel for the appellant submit.
We'll read, just wait.
কোন জায়গাটা রেলিভেন্ট বলুন? 4 দিয়ে রাখো ডিরেক্টলি। 6 আর 9, 4 6 and 9 সেগুলো সাবমিশন। হ্যাঁ, 6 9 এ আসবে। দেখুন
One course.
দেখুন এই প্যারাগ্রাফ দেখুন
খরচ।
ও একটা এক্সটেনশন করে চলে যাও। এখানে অ্যাডভার্টাইজমেন্টে কোথায় আছে? Could not have passed 12th. ওকে একটা কপি দেবো। 10 to 12 is what I was relying upon. Here also, my lord, it was really, my lord, class 8 pass, not less than, should not have passed class 12. That was the condition. My lord, although the, my lord, challenge was succeeded before the writ court and, my lord, the division bench, it was again, my lord, the order of dismissal was restored by the Honorable Supreme Court after, my lord, hearing the essay. So, my lord, I say, my lord, the facts in this case also fall, my lord, the situation is similar, the condition of restriction is similar, and therefore, my lord, he was not entitled to participate, my lord, in the process, and having himself declared falsely, whatever may be the reason why, I am not going into the reason, but he has said that in 2015 he was class 8 pass, which is not correct. So, my lord, I would be, my lord, praying that the order of the, my lord, single bench be, my lord, restored.
Lord, I'll try to demonstrate my lord. Yes. Lord, may kindly takes up page 20 first. 20 of the paper book, Lord. The Bengali advertisement, it says, may I read it in my own way, Lord? It says that শিক্ষাগত যোগ্যতা আংশিক সময়ের সোয়াংশ অষ্টম শ্রেণী পর্যন্ত ইন ব্র্যাকেট অতিরিক্ত শিক্ষাগত যোগ্যতা গ্রহণযোগ্য হবে না। With respect to পিয়ন পোস্ট, it says that অষ্টম শ্রেণী উত্তীর্ণ কিন্তু ম্যাট্রিকুলেশন বা সমতুল পরীক্ষায় অনুত্তীর্ণ ইন ব্র্যাকেট এক্ষেত্রেও অতিরিক্ত শিক্ষাগত যোগ্যতা গ্রহণ হবে না। Now, Lord, kindly takes up the translated page, which is at page 21B of the same paper book. In column B, it says in the middle portion, educational qualification for part-time sweeper up to class 8, additional qualification will not be taken into account. For the post of peon, class 8 passed, but matriculation or equal standard of examination failed. In bracket, in this case also additional qualification will not be admissible. Lord, in the advertisement, there was a Bengali thing which was translated over here. In the Bengali, they have said that the educational qualification will not be taken into account. However, in my case, in the translated copy, they have in their own way translated these things that the additional qualification will not be admissible. So there is a difference between two things, Lord. Why I say this, because with respect to the
This copy of this pleading was served on you long.
Yes.
Have you raised any such issue in your reply?
Lord, we have pointed out before your lordship, Lord.
How can you, when you have accepted the translation without objection, you can make a submission to the contrary?
Very well, my lord. May I say this, my lord?
What kind of submission you are making?
Lord, apart from this,
if at all that was your case, you are required to say
Lord,
so. That's
apart
not a
from
case
this
made
issue,
out
my
for
lord,
you.
May I say this, my lord? Apart from these issues, my lord, they are trying to point out that the additional qualifications will not be taken into account. If I may say it like this way, my lord, what they are trying to establish, my lord, I say that my additional qualifications will not be given into credence, my lord. That doesn't mean that they will debar me for having the qualifications which has been prescribed. My additional qualifications more than matriculation or more than the graduate qualifications will not be given any weightage, will not be given into any consideration.
Inadmissible means that it will not be admitted.
Yes.
It means it will not be admitted. Not that it will not be taken, that it is irrelevant.
No, my lord, in the Bengali,
you are trying to say that it is irrelevant.
Yes.
It does not say irrelevant. It says it will not be admissible. This is the qualification. You have to be 12th not passed. Somehow they have interpreted it as failed. It will not be failed. It means not passed. You cannot be 12th passed.
Lord, however, my lord, in the Bengali copy, they say
in the Bengali copy there is no difference.
Yes, my lord,
there is no difference. It says 8th pass but not 12th pass.
Yes.
And higher qualification, they will be inadmissible.
Will not be taken into consideration.
No, it does not.
That is what the Bengali.
No, it does not. It is not your case. Will not accept such argument.
Lord, apart from the
If you had to make out such a case, there was a time you could have done it. Not in a submission, you cannot make out a case on facts which you have not pleaded. Will not allow you to argue anything you want. Where have you said this? Where have you said this?
very well, my lord.
This translated copy was served on you long back. You cannot make out a case standing here at the time of submission which is not founded on any pleading in the record. You are arguing in a writ proceeding.
Yes, my lord, this translated copy was placed before the Supreme Court also, but in the Supreme Court paper book, they have said that it will not be taken into consideration. My lord, apart from this issue, my lord, may I come back to the other issues, my lord? They have relied upon a guidelines or in the nature of a notification of 2012, my lord, which is not a rule at all, which was indicated before the Honorable Supreme Court that whether any rule has been placed before the division bench or not. Deepest of respect with respect to the rule which has been placed in another paper book, additional paper book, in page 25, they says that this is the rule which has been prescribed or pursuant to which they have made this advertisement, my lord. However, with deepest of respect, in the said guidelines or in the said rule, there is no connotation about the publication of advertisement at all. Yes. May I?
In the rule?
Yes, in the guidelines, my lord.
Yes.
They have said that with respect to this guidelines or notification, they have issued the advertisement in terms of that 2012 notifications or guidelines or rules which they are trying to establish, my lord.
Yes.
However, in the rule itself, there is no connotation about publication of any advertisement. All the requirement things needs to be done by the employment exchange, which we have done. We have not seen the advertisement at all. That is our case that has been pleaded also.
This was a requisition sent to the employment exchange.
Yes. We have not seen the advertisement. We have not made our application pursuant to the advertisement at all because the rule does not permit the bank to frame any such advertisement at all.
So at the time of joining, you are not required to fill up any verification form.
Yes, we have filled up.
Yeah, what have you stated in that form? Your qualification?
In the employment exchange, Lord, we have to say in the.
If we have not seen, but we are accepting what you said, that it was a requisition sent by the bank to the employment exchange.
Yes.
We don't know that above it was a disqualification or it was not to be taken into consideration. Nonetheless, you have not mentioned before the employment exchange that you have a higher qualification.
Lord,
that fact you say I didn't do it because it was an old registration.
Yes, yes.
Now the other thing is, after you were given an appointment, you were required to disclose your qualification.
We have disclosed.
Where is the disclosure? That I have a graduation.
Lord, that has been pointed out. We
Where
have
is
not
that?
suppressed that.
Where is it? Show us. You have said that you are graduates.
Lord, we have specifically disclosed that we are graduate. Lord.
Please show us.
Lord, kindly takes up page 98 of the affidavit.
Yes,
paper book. May I say this? 99 of the paper book. It is my declaration. I say that with due honor and respect, I beg to submit before you that for the purpose of recruitment as peon of your bank, I applied for the said post upon receipt of an application from the District Employment Exchange, Birbhum, wherefrom my name was sponsored. This is my first point. Second, I did not have any higher qualification recorded in the said exchange above my qualification in the extent of class 8 standard. I applied upon.
This is all after it was detected that you have not disclosed.
Yes, that is the first time the bank is asking me to disclose the entire thing.
What is the date of your recruitment? It was published in the Bartaman on 18/3/2015. What are you saying? This advertisement was published in the Bartaman newspaper of 18/3/2015.
Yes, but we have not seen that.
Yes, Mr. Counsel, everything you are arguing beyond the records.
May I say this? That is
may not say such things which are contrary to the record.
That is the reason.
You said there was no advertisement, it was a requisition sent. The date of advertisement is mentioned in the letter which you are responding to. Why you are making false submissions, sir?
Oh Lord, that is the reason.
Why you are making false submissions?
It is not a false submission.
It is a clear and clear case of false submission on facts. Twice you have done it.
But kindly takes up the rules.
What kindly? You also be kind to us. You are here to assist us, not to give us wrong facts, facts contrary to the record. You think that will help your client?
But may I take your lordships to the
We
rule?
don't appreciate such arguments contrary to the records and beyond the records.
But I have specifically pleaded.
You are
with
making false submissions. Very sorry to say. Twice you have done it. This is not expected from any counsel. Two facts you have stated wrong, contrary to the record.
My lord, that fact has been admitted by the bank also, my lord.
What? That there was no advertisement?
No, my lord, they have published.
Just now you said there was no advertisement, there was a requisition.
I say that they have published advertisement.
No,
but
you did not. You said we did not see it because
Yes,
it was
we did not
requisition.
see. They have published. We did not see the advertisement.
There was only a requisition. We asked you
Yes.
that there was only a requisition. You said yes.
Yes.
That is a wrong submission.
Employment
That
exchange.
is a wrong submission. There is a publication date of the newspaper is mentioned here.
My lord,
And you have responded to that letter.
Lord, try to.
Please come out clear with the facts.
May I
Don't
say-
try to do this. Don't do this. You will not appreciate, and it will not help you in any way. You could have told us that yes, there was a publication, but we have taken a stand. We could not see it. You said no, it was a requisition sent to the employment exchange. Wonderful. Two ways of saying the same thing, or two different things. You tell us.
But I say that the bank has published the
Very
advertisement.
well, you proceed. So both points we have considered. What else you want to say?
Yes, my lord. Now, my lord, kindly takes up the rules which they have placed in the additional paper book, my lord. The rules of 2012, which
The
again
most difficult case to consider is when we are unable to rely on you. We would rather rely on you. So every line now we have to read and verify whether it is correct or not. Yes, which regulation you are relying upon?
Lord, page 25, which they have placed in a additional paper book, my lord.
Yes.
Lord, the procedure for recruitment has been envisaged in the middle portion of the page 25. It says that in line with the above named, also in accordance with the existing government guidelines, it has been decided that henceforth the zonal offices of assesses of the vacancies on district basis. Accordingly, zonal offices will place their requisition to the concerned employment exchange, so and so, requesting them to send the names of the candidate registered with them. The second says, to begin with the recruitment of peon will be initiated in rural and semi-urban branches, so and so. For such recruitments would be as under. Zonal office would assess the actual recruitment for pension the branches in their zonal office, depending upon no peon branch in rural under their jurisdiction on or after so and so. Lord, these are the criteria. Thereafter, if I may skip over to column number 2, employment exchange signing director of resettlement may be requested to sponsor the candidates, one, within the locality adjacent to the taluka district where the branch wherein vacancy has arisen, it will be situated. B, two, having domicile in the state for which such recruitment is being made for not less than 10 years. 3 says, while recruiting peons, zonal officers should ensure that norms regarding reservations and other concessions to be provided for SC, ST and other reserved category candidates are to be taken care of in accordance with the existing government guidelines. 4 says, temporary recruitment of peons arising out of leave so and so of the permanent incumbent may also be made with the empaneled waitlisted candidates if they agree to work in the leave vacancy. Lord, my first point is that in the rules which they are trying to rely upon, my lord, there is no envisaged or connotation about the publication of advertisement at all. All the things needs to be sponsored by the employment.
So how it helps you? This submission, how does it help?
Lord, the bank
So they should not have published an advertisement.
That is the reason, my lord. The bank is now challenging their own actions after 10 years.
What is the But see, we are trying to understand, you have made a submission that there is no concept of advertisement.
Yes.
So therefore, how it helps you?
My lord, that will be read into the next things. My lord.
Yes.
The eligibility criteria prescribes that educational qualifications 8 standard but less than SSC matriculation in bracket higher qualified candidates in ineligible.
Yes.
So in the rules for the first time they have mentioned that the higher qualification candidate would be ineligible. My lord.
Yes.
Pursuant to these rules or some guidelines, they have issued the advertisement. However, in the advertisement, which is in the form of Bengali, my lord, they have said that the additional qualification will not be taken into consideration. My lord.
No, they have not said that, sir. Sorry.
My lord.
In whichever language you read it, that is not what they have said.
Lord, may I place the judgment which was considered by the Honorable Division Bench
Yes.
while Lord, this is the judgment of Rina Datta, my lord. It has been reported in 2010 HCC Online Cal 1601.
Mhm. Yes.
Para 11 will be relying upon as regards the question referred by the division bench, where of the view that the question can
Sir,
be
one Supreme Court judgment has been cited relying on two earlier Supreme Court judgments, and you are trying to meet that with a full bench judgment of the High Court.
Lord, they have for the first time. I can distinguish that on the next occasions, my lord.
Next occasion.
Next. Lord, this is the judgment of our High Court in
Whatever
larger.
it is, sir, it is the High Court judgment. You are citing it against the Supreme Court judgment, a recent Supreme Court judgment.
Lord,
What kind of arguments you are making with them?
Lord, apart from the judgment, I have not been given any copy, my lord. I will
They are obliged to give you a copy of the judgment, reported judgment.
I was noted, my lord. I was. My lord, apart from these issues, my lord.
Heard the learned
5 persons. The Honorable Single Judge has directed the bank to consider, look into the candidature of 5 candidates. One of the applicant was here, and the next matter, another applicant. So 3 others, they didn't participate. They didn't challenge the transfer.
So we are only considering his case.
Item 20.
That I am appearing on behalf of the appellants.
My lord, for the respondent, Mr. Kollol Basu is leading me. My lord, he's supposed to be online. He's not here, my lord. He's in Jalpaiguri. Would my lord be pleased to take it up tomorrow?
Any problem tomorrow?
But then next week, my lord, any day.
Tell us when.
My lord, 4th or 5th.
As jointly paid list on 4th.
Item number 21.
I am for the appellant writ petition. And this is the case, my lord, where the writ petition was terminated without any due process of law.
I am for the respondent, my lord, led by Mr. HON'BLE.
I invite your lordship's attention to the writ petition because the appointment letter first. The learned single bench, my lord, admitted that it was the illegal proceedings, but did not interfere with the order of termination. That's why we are here. Your lordship kindly have a look to the appointment letter. Page 22 to the writ petition. Your clause 1. Your service will be guided by the CSTC employee service regulations. Your lordship can note. Your service will be guided by CSTC employee service regulations. Next, my lord, the physical probation initially for a period of 1 year as envisaged under regulation 17 of the CSTC employee service regulation, which may be extended by 1 year, and under regulation which may be extended by 1 year, and during probation your service may be terminated on 48 hours notice without assigning any reason. Now, the petitioner completed 2 years of probation period, and according to regulation 17A, he will be deemed to be confirmed. Now clause 4. The appointment will be subject to your antecedents and character being found satisfactory. He will be deemed to be confirmed in service on satisfactory. And that does not mean that the employee would wait for an indefinite period for his completion of probation period. According to regulation, Miller, he completed 2 years of service on probation, so he would be treated to be deemed confirmed. Now, your lordship kindly have a look. I have already handed up the regulations, Miller. Your lordship kindly have a look. Regulation 17 says, unless otherwise provided in an individual contract, all employees except employee of officiating appointment shall be on probation for a period not exceeding 1 year, which may be extended up to 2 years at the discretion of the appointing authority. During the period of probation on the service of the employee may be terminated within 48 hours notice and without assigning in the clause amended by Annex 3. Now, during the probation period, he was not terminated. You will logically have a look to Regulation 17A that was amended, page 9. After Regulation 17, insert the following, page 9 bottom. After Regulation 17, insert the following regulations, namely 17A. An employee who has successfully completed the period of probation referred to in Regulation 17 shall be deemed to be a permanent employee. So maximum period is 2 years. On completion of probation period, he will be deemed to be a confirmed employee as per the regulation. Now, your lordship kindly come to regulation. According to the appointment letter, he is to be guided by the CSTC employee service regulations. Now, your lordship kindly come to 38, regulation 39. That says not. No order of dismissal, removal, or rejection shall be passed on an employee of the corporation other than an order based on facts which had led to his conviction in a criminal court, unless he has been informed in writing on the grounds on which it is proposed to take action and has been afforded an adequate opportunity of defending himself. The grounds on which it is proposed to take action shall be reduced in the form of the definite charge or charges which shall be communicated to the person charged, others which is proposed to take into consideration in passing orders in the case. He shall be required within a reasonable time to put in a written statement of his defense and state whether he desires to be heard in person. If he so desires or if evidence shall be heard as to such of the allegations are not admitted, and the person charged shall be entitled to prosecute. So there is no. So they have violated their own regulations. According to this appointment letter, I am to be governed by the CSTC employee service regulations. Now you will kindly come.
So what is your grievance about the order of the learned single judge?
Learned single judge admitted that the order, that the disciplinary proceeding, there was no disciplinary proceedings and it is illegal. Order is illegal. But it did not touch the order of termination of service. That is my only grievance, and that is why I am in the appeal.
Yes, tell us.
She will find
You have not filed an appeal against the order.
no, we have not filed.
Therefore, the finding you are is not in dispute. Now, having recorded such findings, can he be deprived of the consequences of such finding?
May I just clarify what culminated?
No, he may have committed the biggest, according to you, biggest misconduct. But the order is on the basis of suspicion recorded by the Honorable Single Judge. There is a suspicion regarding his nationality, which he says cannot be done without a hearing. This is an admitted position, not disputed by you. Now, once he has said that he must be given an opportunity of hearing, how he can be proceeded against if he is out?
No, my lord, may I place what here my friend has placed the appointment
No, that
letter?
is not required. That's not required. The findings of the single judge now are binding on you.
But I say, my lord, that
therefore there is no question of looking into anything.
So in appeal also the respondent can also, my lord, challenge the findings.
You have not done so. You have not done so.
As per CPC,
we are considering writ petition. You have not done so.
Under Rule 53, my lord, the code of
You have not
procedure
done
can
so.
be,
You have
can be
not
relied
done
upon what the rules will apply mutatis mutandis. That is our, my lord, writ rules. Rule 53 that I can rely upon the provisions of CPC, my lord, so far as applicable.
Whether Rule 53 or not, that is the law governing the country. As far as practicable, there is the principles will apply. Provisions will not apply.
In as per CPC, my lord, the principle is, my lord, that in an
But you are not challenged, so let us not get into that. These are findings of the single judge.
I can challenge the findings in an appeal being a respondent.
You have not.
No, without challenging, without preferring also, I can not say, I can argue that.
Then make your submission.
I'll make on that. Before that, but I wanted to not place the facts because the facts not has not been placed in its entirety. What has been shown today is the appointment engagement as a
no, without articulating a challenge, you can argue against the judgment. Show us which provision enables you to do so.
My lordship will kindly give me 1 day's time, my lord, because
come tomorrow, not today.
Because on the previous day, my lord, the argument was that he's
no, forget about previous day.
We have of Article 311.
Forget about previous day. Fine. The findings of the single judge are now conclusive. So how he can be deprived of the consequence? That is the only thing. You proceed against him. You give him a charge memo. You conclude it within 2 months.
I can
3 months, whatever you want.
The findings as a respondent also under order for
tomorrow. Post tomorrow any judgment or any provision which allows you to reopen things now in the present circumstances.
I'll come.
We'll proceed. We'll proceed accordingly. Yes.
Can it be day after tomorrow, my lord? Day after tomorrow. One more day.
Tomorrow. With not today.
Item 22.
Number 1. On behalf of Mr. Bodhiju.
When do you want it? You are for respondent. This is an appeal.
I don't have the brief.
As paid list after 3 weeks.
18. After yoga. 18th August. Item 23.
Lordship, I am for that. Last occasion, my lord inquired about the pension rules. In this case, my lord, third pension has been paid and one third pension is and claiming to interest on that one. My lord, kindly see. Bengal Government Vikas Bank Employees Pension Regulation 15, 2018.
Where is, just show us, so what was your prayer in the writ petition?
Here for pension.
Where is your prayer in the writ petition? In the writ petition.
My lord,
Page 45. But page 45 of the writ petition. Page 45 of the writ petition, they have annexed in the appeal.
File paper book. It's not possible to proceed like this. File a paper book. Cannot proceed like this. File a convenience compilation, whatever you are relying upon with the writ petition.
I'll do that. Otherwise, my lord will not heard the matter.
No, we will not. We are going through the record, therefore it's not possible. Let a convenience paper book. Don't call. Yes. Say wrongly listed, call it and say.
Item 24. 24.
24.
Wrongly.
It is wrongly.
Item 25.
25 to 28. Similar matters, 25 to 28.
All.
All. There was a direction to file an affidavit in reply. I'm seeking a day's time to file my reply, and there was a convenience paper book also required. For that, I require further 3 weeks' time.
Further 3 weeks.
Your Lordship, because the pleadings has got completed only now. I've served my learned friends with the advance copy of the affidavit
Of the reply.
of the reply.
You will file it today.
Your Lordship, I'll file it. It will be affirmed at 3 p.m. today. So I'll file it within the course of the day.
We are informed by the learned
Union of India itself requires
It's
a week's time.
2 weeks time, my lord. Into 4 weeks.
All matters after 4 weeks. There is no interim order obtaining.
25th August.
25th.
The initial observation your lordship has made in the order, wherein what action has the institution as well as Union of India taken, itself suffice that.
Or we don't remember, don't rely on our memory.
In this case, what had happened, the institution on its own had
Oh,
implemented.
correct. Now we remember. Revise the scale or something.
Revise.
Item number 29.
Respondent bank led by Mr. Boydruju Ghoshal, Lordship.
Yes, sir.
Paying for short pass or engaging in code number 18, Lord.
Holding Holding ভুললে না তো আমাকে রানী করতে হবে
Sir.
You are not satisfied by paragraph 9.
Mind. But the revocation of suspension was effected before the second disciplinary proceeding was initiated.
When it was revoked?
But the suspension was revoked on 6th of February 2025.
25. And what is the date of charge memo in the second?
28th of March 2025. That's the second charge sheet.
So you are claiming till 28/3.
But from the date of suspension till the date of revocation.
No, why not till 28/3? Revocation is in February.
Revocation was in, I'm sorry, 6th of February 2025.
But you will get it till 28th March because
28th
charge memo was drawn.
It was, yes.
So what is the date of suspension?
The date of suspension is 20th of December 23. But I have a very short list of dates.
They filed an opposition in the writ proceeding.
The stay application does not disclose so, but not as it has.
The first charge sheet is dated?
The first charge sheet is dated 20th of March 2024. Not the second entry in the list of dates.
And the second one is 28/3/25.
28th of March 25.
And where is the final order passed in the charge memo of 20th March 24?
The final order is dated.
It is dated 6/2/25. Where is it?
No, 6/2/25 is the revocation of suspension, page 47.
And final order?
Final order of punishment is 25th of June 2025.
So where is 6/2/25?
Page 47.
ফরমাল বলেছে তাহলে এখানে ঠিক আছে
অপোজিশন ফাইল করেনি তোরা সিঙ্গেল বেঞ্চে?
হ্যাঁ
সিঙ্গেল বেঞ্চে অপোজিশন ফাইল হয়েছিল?
হ্যাঁ
And where is the punishment order?
Punishment order is dated at page 84.
without hearing, giving opportunity of hearing. Inquiry officer, presenting officer not appointed.
So this does not say anything about the period of suspension.
The regulation I have quoted not in that note. Please take the regulation 48. And we also have copies note, whichever is convenient to your lordship. I can hand over the copies also.
Take two.
We're relying on two.
This suspension was but from any number 5625.
দাঁড়িয়ে গেছে দেখে
If you are doing if he is not there is a second charge.
Yes.
There needs to be produced some documents, my lord. I am praying for short possible lordship. There, in this matter, my lord, there needs to some production of some documents. I need short possible lordship. As my lord, Mr. Bodhuji Ghoshal is engaging court number 15 lordship. I am praying for short possible.
Ask him to come. Where is he?
Lordship.
23 ডিসেম্বর থেকে ওখান থেকে এই অবধি পাবো। কোনটা এগেনস্টে মানে কে? Oh. Not I beg to not be excused, but I'm told not I don't recollect, but not at one point of time the bank might have conferred with me on this matter. Not I don't exactly remember. Not. Just now, not I am told by my learned friend.
So what should we do? Tell us.
Kindly not adjust this matter for that. I shall retard this. If it is so, not I shall retard.
Not today.
If for any what conference হয়তো করেছিল বলছি। And I don't recollect what if there be so I
It
shall
happens. It happens.
Item number 30.
ठीक है 30 Motion 30.
So 30, I beg to appear on behalf of the appellant petition. By virtue of the order impugned, my lord, the order of appellate authority is order of dismissal and service. Imposing, my lord, major penalty has been turned down, my lord. Consequentially, my lord, the learned single judge has, my lord, quashed, my lord, the entire inquiry report. Although, my lord, in the writ petition, my lord, the writ petitioner did not challenge the inquiry report. He accepted the inquiry report. Thereafter, my lord, challenged, my lord, the dismissal order as well as, my lord, the order passed by the appellate authority. So, my lord, I have prepared a short list of dates, my lord, for your lordships.
Yes, where he has quashed the inquiry report.
Your lordship may kindly have a look to, my lord, the impugned, my lord, order at page 300, and it starts from, my lord, page 332.
Page?
Volume 3, lordship, page 332.
Internal page of the judgment order.
My lord, internal page of the judgment, my lord. Lordship, kindly see. Lordship kindly sees page 336. Lord, the top of it, Lord, may I just read, Lord, some portion, Lord, from page 335.
Please give us internal page of the impugned order.
Internal page is page 14. Page 14. Milord, about Milord, last 9th line, Milord, from the bottom, Milord, even after.
No, you said the inquiry report has been quashed.
Yes.
Where is that we are asking you? Please read from the judgment.
Milord, may I just read, Milord, even after, from even after.
Yes.
Even after the petitioner had identified several discrepancies in the inquiry officer's report, the same were not considered by the disciplinary authority. Having regard thereto and noting that the petitioner had raised several issues including admissibility of the third-party electronic evidence, the least that was expected from the disciplinary authority was consideration of the objections raised by the petitioner. The same was not done, and the entirety of the inquiry report was accepted by the disciplinary authority by a cryptic order, and punished that was proposed was obviously based on the findings of the report, including the proof of certain allegation which did not form part of the charges. The aforesaid clearly demonstrates that there has been complete non-application of mind by the disciplinary authority. The disciplinary authority had only lent its signature by arriving at a finding without considering either the charges or the findings returned by the inquiry officer. There also appears to be no consideration of the response filed by the petitioner, although the findings had been relied on by the inquiry officer that the petitioner had abused his high post and sought to satisfy his sexual urge in the manner unbecoming to his post. Such charge also did not feature in any of the articles of charges leveled against the petitioner. So and so was never produced to the victim. The findings reached on by the inquiry officer is perverse and is not supported by any evidence. The entire inquiry proceeding, in my view, stands vitiated. Further, considering the fact that more than a decade has elapsed, no fruitful purpose will be served in directing the consideration of the inquiry officer's report by the disciplinary authority, as the writ petitioner has already reached the age of superannuation and the master-servant relationship has come to an end.
So there is no quashing of any inquiry report.
No, it says it has been vitiated.
There is no quashing of the inquiry report, sir.
Lord, my humble submission before the learned
You can
single
make
judge.
a submission, but please give us the correct facts. Why should you say that it has been quashed when there is no quashing of the inquiry report? Yes, now proceed.
Now, Lordship may kindly have a look to, my lord, the prayer, my lord, made in the writ petition.
Yes.
Page? Yes. It's 39. Lordship kindly sees, my lord, volume 1, page 39. Lord, prayer A is, Lord, writ in the nature of mandamus, commanding the respondents not to give any effect or further effect to the impugned second stage advice of Central Vigilance Commission made annexed at P5. Lord, on the basis of second stage advice, Lord, the investigation was done and Lord, the proceedings started. Now B, writ in the nature of mandamus, commanding the respondents not to give any effect or further effect to the impugned resolutions and orders of the disciplinary authority and the appellate authority made annexed P6, P7, P12, P13 herein, and further directing the respondents to reconsider the petitioner's case afresh by the disciplinary authority in strict accordance with law. Now, my lord, prayer C is writ in the nature of certiorari, directing the respondents to transmit, authenticate the records of the case to the honorable court, so that concernable justice may be administered by quashing the impugned advice, resolutions, and orders made annexed P5, P6, P7, P12, and P13. Then, my lord, D, writ in the nature of prohibition, prohibiting the respondents, their men and agents, assigns, and subordinates from taking any further steps and stroke or giving any further effect to the impugned advice, resolutions, and orders made annexed P5, P6, P7, P12, and P13 on any alleged ground whatsoever. Now, my lord, these are the, my lord, sum and substance of the main prayers. Now, my lord, this annexed P5, P6, P7, and P12, P13 are, my lord, not, my lord, the inquiry officer's report. It is, my lord, they are, my lord, in fact, my lord, the dismissal order passed by the disciplinary authority as well as, my lord, the appellate, my lord, authority's order. They have challenged. Not beyond that. Now, my lord, my humble submission before the learned single judge was, my lord, in case, my lord, they do not challenge, my lord, the inquiry officer's report, my lord, the Honorable Supreme Court, my lord, already, my lord, passed, my lord, in several occasions orders that, my lord, the disciplinary authority accepts the inquiry officer's report, but that becomes final, my lord, no further reasons are required to be, my lord, given. Below the annexure P5 is page 54.
So this is after the disciplinary authorities order.
Below the, this is before 2017.
And what is the date of charge memo?
Below the date of charge is
30th of March 2015. 30th March 2015.
So it's before this.
Yes, Milord, the article of charge, Milord, was given, Milord, on 30th of March 2015.
And inquiry officer's report?
Inquiry officer's report, Milord, submitted reports on 29th of April 2016.
So this was after acceptance of the report by the inquiry officer.
Milord,
this charge memo is at which page?
Milord, the charge memo is at, Milord, page 98, paper book 1.
And inquiry report?
Milord, inquiry report is page 233, paper book 3.
So it says the commission is in agreement with the DA.
Hello.
So this means, what does it mean? It is after the order passed by the disciplinary authorities.
Milord, the disciplinary authority, Milord, passed its dismissal order on, Milord, may I just take your lordship to that, Milord? Yes, Milord, 17th of October 2017, page 56.
Seventeenth
of October, Milord, 2017, page 56. He preferred appeal, Milord, on 29th of October 2017. And Milord, the appellate authority, Milord, dispose of, Milord, the appeal, affirming, Milord, the same. Milord, on, Milord.
We'll have to fix this for hearing. It will have to be heard.
But only one humble submission I was making. Not he had been working in this establishment after getting a transfer from some other establishment. So, not his accumulated gratuity, provident fund, and leave encashment, apropos his service with the erstwhile employer, had been transferred to this establishment. So, whatever has been transferred to this establishment, that may be released.
Milord, already, Milord, they have, Milord, filed a writ petition, Milord. That is, Milord, a part of, Milord,
purpose of release
item
of
number,
mineral dues.
Milord, item number 35. Milord, we also preferred and challenged, Milord, in appeal. Milord, my Lord,
The pro rata gratuity, pro rata leave encashment, that is admissible dues.
the Honorable Single
This
Judge
has been paid to him.
No.
Milord, Honorable Single Judge has directed us to release the admitted dues. Now, Milord, the problem is, Milord, this is, Milord, pendency of this appeal, Milord, this order was passed. Now, if your Lordship kindly grants us a stay for a limited period, otherwise, Milord, will be, Milord, hold up in contempt.
So irrespective of what may happen in this appeal, why he will not get those dues?
Milord, the dues, Milord, are not admitted to my humble submission. Because, Milord, the learned single judge in this particular matter has not only, Milord,
Consider when 35 is taken up, we will consider. The direction is in that case. We will consider. This you want to file. Should we proceed like this? File a paper book, proper paper book.
Milord, I'll file a paper book.
Yes. Let paper books be filed.
On the other side, matter item number 1.
My lord, I am for the
My Lordship, I am for the Respondent Transport Corporation. My Lordship, Advocate, Senior Advocate Behani, Launcher Behani sir is, okay, my Lord.
the
And adjournment
corporation is
to my
the
Lordship.
answering respondent. But my lord, I want to draw your lordship's attention to the impugned judgment and order. My lord, order dated 17 December 2025, my lord. The copy is annexed with my stay petition as well as the. May I read this order, my lord? In the writ petition order, but if your lordship has gone through this judgment, my lord, there are 3 points which I would like to raise today. One is that the findings arrived by the learned single judge regarding the non-existence of the scheme at that particular point of time is, my lord, wrong. Number 2, my lord, the finding arrived by the learned single judge regarding this Upendra Kumar's decision, my lord, that finding was wrong. And third is, my lord, the learned single judge has also observed in paragraph number 7, which starts with moreover, what is striking, the petitioner was indisputably minor on the date of death on 29th November 2007. It appears from the affidavit in connection with the present writ petition that the present age of the petitioner is 32 years. Therefore, on the date of death of the employee on 29th November 2007, he was minor. It's my admitted case, my lord. In the case relating to the appointment on compassionate ground, unless scheme provides a minor at the time of the date of death of employee has no right to be considered for the appointment on the compassionate ground, the ratio of Upendra Kumar will not apply in the present case, since it was not a case of appointment of a candidate who was minor at the time of date of employee. In this regard, reliance is placed on the judgment of the Honorable Court, such and such. But the law, position of law is correct, but application is wrong because of the fact, my lord, that there was a scheme. Lordship, kindly come to the scheme, which is annexed in page number 31 of my stay application, my lord.
No, when your application was made, what is the date of application?
My lord, my application was first made by my mother. That was in 2007, within the time, my lord.
Lordship, kindly come to page number 19. Lordship will find that this was the reference to the application from the employment in CSTC on dying harness grounds. She is requested to submit. They wanted my mother to submit the income certificates and all, which is, this was addressed to Joy Dash. It's on 11/3/2000. Next page, my lord, 12. This was addressed to the managing director, and in enclosing the following self-explanatory representation along with the enclosure, I am directed to request you to take necessary steps. Then my mother's representation, my lord, 3/1/2012 from Deepa Dash. My mother wanted to get it converted, my lord, to me.
Where is that?
My lord, kindly come to page 20. There is one single reference to one letter of my mother. Lordship will find in enclosing the following self-explanatory representations along with its enclosure, I am directed to request to you necessary action as admissible in terms of the government rules. That is number nil dated 3/1/2012 from my mother.
And when your first application was made, we have.
My lord, this was within time, my lord. That was not
when your first application was made.
My lord, that
your father died in harness in November 2007.
My lord, yes, my lord.
Yes. In your writ petition,
kindly come to.
In your writ petition, what you have pleaded when you made the first application? Please show from your writ petition.
From the pleadings, sir. But Lordship, kindly come to paragraph number 4, 5, and 6. My lord, of the writ petition, my pleadings. So far, the documents are there. I cannot show any documents in respect of this, but I say your petitioner states that his father, namely Ravindra Chandra Das, was a permanent employee of CSTC as fitter, and unfortunately, he died on 29 November 2007. While he was in service, leaving behind the petitioner and petitioner's mother, namely Deepa Dash. Your petitioner states that at the time of the death of petitioner's father, he was minor. Therefore, his mother, Deepa Dash, made necessary application for appointment on compassionate ground as the petitioner and mother were fully dependent upon the petitioner's father. However, the petitioner, being adult, made application for appointment on the compassionate ground, and petitioner's mother also recognized the same. Your petitioner states that, but after a lot of correspondence in February 2011, the deputy managing director of the corporation dealt the application, and the petitioner had transmitted a letter with request to furnish the same some documents. So this was only from their side. In 2011, they wanted some documents to be furnished. So refer therein for appointment on compassionate ground as per the direction of the petitioner, complied with the said order. And on the other hand, on the basis of another prayer made before the authority concerned, the WSD ex officio Special Secretary of the Government of West Bengal Transport Department intimated the Managing Director of the corporation to take necessary steps for petitioner's appointment on compassionate ground, but no effective steps was taken, and therefore necessary application was further made on the basis of all efforts in June 2020. Your petitioner was appointed in the respondent corporation as a conductor. Well, that is the Lordship catch. He was appointed as a conductor under the agency.
At the time of demise of your father, you were 11 years old.
11 years. My lord, what happened? They engaged me under an agency. But compassionate appointment cannot be made under the agency. He is presently working as a conductor under the same corporation, but it's under the agency. It's not a permanent job. Through agency, and said appointment letter was signed by the joint managing director, but the copy of the appointment letter was not handed over to your petitioner. The entire process was conducted through telephone, and then your petitioner was sent to WBTC for performing duty. Your petitioner has been working for. Thereafter, my lord, kindly come to paragraph 7. Your petitioner states that in tension there is no document in hand to prove that he has been engaged by the corporation on compassionate ground, and that too through agency. In spite of the petitioner made an application for having permanent status in service. At the same time, petitioner's mother made RTA application on 15 February 2022 and 29 June 2022. No few points. Information in respect of your petitioner's service status.
When you were engaged on contract basis?
My lord, I was engaged in 2020 June.
20 June.
June 2020. And my lord, the pleadings is in paragraph number 6. But in 2011, I have submitted the requisitions.
In 2006?
2011.
When you were engaged on contractual?
2020.
20.
June 2020. Paragraph number 6.
And you are relying upon which judgment? Upendra Kumar, where is that?
Upendra Kumar, my lord, was judgment. Judgment. But
you don't have.
But I'm sorry, my lord, he is not having.
Tomorrow? Not today.
I'm sorry, my lord.
No, all right. Don't have it. What can be?
Or it come tomorrow.
Tomorrow we have any matters, original side?
Yes.
Thursday. It will come on Thursday.
Thursday, my lord, kindly keep it somewhere so that it can be reached on that.
No, it will be, we have the original side matters at 2 p.m. Yes.
Welcome. Thursday, my lord.
It's recorded in order as prayed, list on.
Item number 2.
I am for
Mallory
the
Knight. Mallory Knight. Number 2, my lord, before my learned friend starts, my lord, I beg to appear on behalf of the state. My lord, I do not have the copy of the repetition, or my lord understands after the new regime, I do not have the copies of the cost papers. I'll request my learned friend to provide me with the copies and thereafter to proceed, my lord.
Already we are not able to understand what you are saying. Voice is
My
muffled.
lord, I beg to appear on behalf of the state, my lord. My lord may understand that we do not have the copies of the cost papers. After the new regime has come, my lord, we do not have the copies. They must have served earlier. But my lord, I'll request my learned friend of the for the petitioner to provide me copies of the cost papers and then to proceed.
We don't know. You take a copy from him. He'll not keep giving copies to every new.
My lord, may I am appearing for the respondent number 227, my lord. My lord, the copy of the memorandum of appeal has not been served upon me. The application.
7.
Respondent authorities, Calcutta Tramways Company.
Huh?
Respondent authorities, my lord. My employer.
No, there is a state and there is another authority. Which authority?
There's a respondent Calcutta Tramways Companies. That is the my employer.
Anyway, we'll have to hear the matter because it arises out of a disciplinary proceeding.
No, it arises out of a order whereby my pension option form, which I have been submitted in 2001, pursuant to the pension notification, that got lost from the custody of the employer. The employer denies that I have never submitted the pension option form. Even if I have submitted, there is an interpolation in my pension option form, and the corresponding entry in the peon book does not bear the signature of the receiving authority on the event date. But I have annexed those documents, my entire peon book, if your lordship may see, that does not, or each and every entry does not bear signatures.
It does not arise out of departmental proceeding.
No, it does not arise out of a departmental proceeding. In 2002, there was a cutout date. Within the cutout date, I have submitted my option form. In 2011, when there is a transfer of the department of the CTC from one building to another,
which order is under challenge?
Order passed by the Honorable Single Judge, my lord, dated.
No. Which order you have challenged in the writ?
Order refusing to reconstruct the file so far as the pension option form is concerned.
Where is the prayer in the writ petition?
Yes, my lord, may kindly seize the prayer.
Which volume?
Volume 1, page 15. Page 15 is the starting of the writ petition. If my lord may kindly turns to the prayer portion at page, may I just indicate? At page 43 it starts, but relevant prayer is at page 44. May I please? A writ in the nature of mandam at page 44 of the volume 1 be issued commanding the respondent or respondents concerned to treat the petitioner as an optee for the pension scheme on the basis of the option form submitted by him as reflects in annexure P1 to this writ petition by reconstructing the pension file as per law and to release the current pension month by month along with arrear pension from November 2020 with 12% interest and to take such further steps or other steps in accordance with law by setting aside the order dated 16 January 2020 passed by the managing director, which is the annexure P2 to this writ petition. But 16 January 2020 is an order which passed by the department which was incomplete. Later on, by the leave of the court, this incomplete order was sought to be completed, which was filed by a supplementary affidavit to which I have filed my opposition, and subsequently reply was given by the respondent corporations.
What is P2?
P2 is the order that has been sought to be set aside before your lordship, before the honorable single.
P2, where is P2? Which page?
My lord may kindly turns to 16 January 2020. My lord may kindly turns to is at volume 2, page 249. Page 49 to 257. My lord may kindly turns to the last page. At 257, your lordship will find that the initial order, that was an incomplete order. That was never been served upon me. When I filed a contempt application, they annexed this order in my affidavit, in their affidavit of compliance, whereby the Honorable Single Judge was pleased to grant me leave to challenge this order. When this order was challenged in the instant writ petition under appeal before your lordship, the Honorable Single Judge directed to complete this impugned order, or complete the remaining part of the impugned order, which was subsequently passed by the incumbent managing director, and that was challenged by way of a supplementary affidavit. Enter on surmises and conjectures, the Honorable Single Judge was pleased to reject the writ petition, dismiss the writ petition on the ground that the initial option form was never produced before the Honorable Court, or it was never been made a part of the writ petition, or it was never been shown.
So where is the original option form?
I have with me. I can show to your lordship.
Where is it? From the record?
Yes, my lord may kindly turns to the first annexure. Option form, your lordship will get at page 76 of volume 1.
You are referring to 28th June 22, 28th June 2002.
Yes, ma'am. 20th June 2002.
And when the option was invited?
Yes, my lord may kindly turns to page 75.
When the options were invited?
Options were invited on 1st of March 2002 with a cutout date of 24th June 2002. Those who are existing employee under contributory provident fund, if they are willing to switch over from CPF to GPF, they must make an application. They must file the. They must fill up the option form. That option form was filled up on 20th of June 2002, and the signature of the receiving evidence of the my superior authority foreman or the superintendent RST, meaning rolling stock Taliganj depot, signature appears. That was lost from the custody. I made an application for reconstruction. My reconstruction application went up to the managing director level. Thereafter, again, my application for reconstruction also got lost. I made an RTI putting certain question to the managing director that you ask this foreman whether it is a signature, whether you have appointed a handwriting expert to verify that whether this signature is of the foreman. The foreman was in service till 2015 when the affidavit of opposition was filed just after his retirement. This is at page, my lord, I will show to your lordship another document, the relevant document, the peon book at volume 3. And the managing director made an observation. If it is found that he has applied for option within the cutout date, the same should be taken into consideration. I will take your lordship to the findings and the decisions of the Honorable Single Judge under appeal.
Yes.
My lord, may kindly comes to the paragraph 18 and 19 of the order under challenge.
We'll fix it for hearing.
My lord,
We are fixing it for hearing. Let them,
Fine.
give them copy.
my lord, if it commences to your lordship, would it be after 11th?
After?
11th of August? Subject to your lordship's convenience.
Yes. 24th,
My lord.
we fix this matter for consideration. You give copies to them, whoever requires.
The copies I have already given to the respondent. They are the main.
All respondents.
Mainly the answering respondents. There is only state of West Bengal is there. But state of West Bengal, it has been served upon the advocate and record office of the advocate.
No, the contesting respondent will be the
respondent 227, which is present.
My lord, I have not received the copy of the memorandum. The memorandum may be served. The applications have been served.
My lord, I do not refute that they have not served. I am requesting, since the new regime has come, I have not the copies. I am requesting for copies. I'm sure my learned friend will give.
Yes, you see, if it is required, you can give it.
But I filed the affidavit of service.
Affidavit of service is recording the order. Affidavit of service is kept on record.
Grateful, my lord.
Affidavit of silence.
You know 31?
2 p.m. to 2 p.m.
To be number 44.
সার্ভিস 2 কপি দিতে ও 2 কপি লাগবে এটা রাখুন আমি একটা কপি আরেকটা কপি করি Yes. Gotcha. Any. একটাতেই আছে annexure গুলো Your Lordship. Application after Lordship judgment delivered on December 2025. Upon date application WPST 147 of 2025. Petitioner's case was proceed, my lord.
Learned advocate who had appeared in the writ petition.
Yes, writ petitioner, somebody.
No, it is the same council or the council is different.
Shapam Banerjee, Sumita Bino, of the petition, Gangadhar Das and Pranay. But in a review application and here the husband by.
How it can be?
In a review application, new application.
A review, if it has to be by the same council or the same arguing council or with NOC.
এটা কি নতুন ওকালত না কি? No objection দিয়েছেন। Well, since it has a dispute matter, in a review application, perhaps well, a new lawyer can.
We have already passed an order, a judgment on this point.
That's right.
Relying on various precedents. So we cannot take a view contrary to that. We have considered the law emanating from the Supreme Court judgments, a review. If filed by a different lawyer, then it has to be with a no objection.
With a no objection.
Yes, that is a minimum requirement.
I will not. So, not aware of this. If it is a court in that case, I have to get.
Oh, because we have considered this aspect in one case. Therefore, I don't remember in which case, but we have considered this aspect.
Yes.
With reference to certain citations.
Give back the consideration
With justice, in the prior bench, we have considered this aspect.
Perhaps asking the court not to give the court consideration of the entire case when making review. I'm not sure the same lawyer will have to make it. Because it is not a matter. Because it is not a matter.
We will request your assistance on this aspect. We will request your assistance with reference to the judgments. Either you can show us a judgment so that we can take a view otherwise, or you can utilize the time for taking a no objection, whatever.
All right, but I think that it is stand over to some other day.
Next week? Within a week or 2 weeks, how much?
At
Let the matter be. Decided you should examine the issue.
I'm so sorry, my lord. It's my embarrassment also.
No. Yes. Not at all.
But I have to also examine because I was not aware.
See, because I'll tell you, I'm switching. The affidavit of service is kept on record.
Affidavit service.
Yes, we have taken it.
731.
But I am for the private respondent petition. Well, Mr. Shaunak Ghosh is appearing on behalf of the appellant. That matter, your lordship. For rounding off of 169.5 and above.
Who is for the others?
Mr. Shonak Ghosh is appearing on behalf of the appellant.
Ask him to be here. You are for the respondent.
Respondent is petitioner.
None appears for the appellant. Aryan.
Can it be taken out Tuesday?
Yes.
And 32. 32, my lord, I am for the private respondent is petitioner.
Him.
Same, my lord. He is running from the another court, my lord.
He is coming.
He is coming. Yes.
He is coming, then all these matters can be disposed of. Why you are still filing appeals?
But these were filed in February, my lord. But if it can.
The appeal is of 26.
No, it was my humble request of instructions that a stay application has to be filed to only to bring documents on record. Thereafter, whatever falls from it.
Nothing. Don't do this. You know the legal position. What stay application you will file?
Only to bring the document on record. Thereafter, my lord.
No, required. We'll pass the same order. Why stay application is required? When you are taking a file stand, then you will file
as an officer of court, I cannot take another stand, but that is the instruction of my.
Make it whatever instruction you want. We'll reject such instruction.
As an officer of court, the position is clear. It is.
Point in
has held
procrastinating in these matters. So you are appearing in the earlier matter also.
Earlier matter in the next matter as well.
Give the file of 31. You know the same order has to be passed. Where's the question of passing filing any?
I'm done it. Huh?
It is filed within time or outside time?
I think it is within time because there is no defects integration in the app.
But all three are within time, my lord. Within time, memo of appeal has been filed, my lord.
That first paragraph can one it will not be there, I think.
Before this Same. Much of it. Grateful to Lordship.
Right? Send the file to him also. Or because of
Madam 34.
About I beg to appear the appellant, my lord, date petition. Have served upon the respondents. Well, 11th May 2026 is the order implemented for your lordship.
Yes.
But only, my lord, point before your lordship, my lord, that I'll agitate. But is the fact that in this particular matter, my case is covered by the exception, my lord, which is, my lord, taken out in the rule of compassion appointment in the state of West Bengal by the Labour.
Exception?
My lord, which is, my lord, taken out, my lord, in the rule of compassion appointment of the state of West Bengal, my lord, that exception, that delay in making the application in exceptional case, my lord, when there is no alternative persons who are eligible for the compassion appointment at the time of making the application. My lord, that was there, my lord, which was considered by the my lord, department concerned and held that yes, they are satisfied that yes, at that particular time there was no, my lord, competent person who could, my lord, apply for this. So that is the reason for which we accept the delay. The department says that. And after that, my lord, they did not do anything, for which, my lord, I have come before this honorable court by way of filing a writ petition. Only that, my lord, page I'll just take your lordship to, my lord. My lord, if I request your lordship, my lord, to see, my lord, only page number 56 once of the stay application. Because I have already, my lord, come across with a judgment, my lord, passed by this honorable court on 10 AA of that particular, my lord, notification. But after page 56, there was another reminder by the department itself, but even then, my lord, nothing happened. Thereafter, my lord, I came before this one.
You're relying on 56, P10.
Yes, ma'am. Page number 56, ma'am. P10.
So this is based on which application?
My lord, based on the application which I initially did, which is, my lord, in the year 2014.
No.
But that
Please read paragraph 14 of your writ petition.
Yes, yes, ma'am.
Please don't say that it is based on an earlier application. You asked for a reconsideration.
Yes, ma'am. That was my.
Now saying that my mother was unwell. Did you ever challenge the order at page 55?
At page 55, after page 55, I said that your observation is not
Very
right.
well, all right. So we have understood your
Yes,
case. What else?
that is only my case before your lordship. Because if I just could, my lord, address your lordship, because the lordship has seen, my lord, 10 AA, where, my lord,
That does not apply. We are very clear. That will not apply to you. We know 10 AA, that will not apply to you.
my lord, I, with my lord, humble submission before your lordship, my lord, that the delay, the reason, my lord, of my
will not apply, sir. Any document prior to page 55, you show where you have said that your mother was ineligible. So any document prior to page 55.
My lord, I have, my lord, what happens?
Sir, we will rely only on contemporaneous things, not as you evolve, you cannot make out a new case.
I am not making out any.
After your father's retirement.
If I just could say this, my lord, I have specifically pleaded, my lord, in page number, what you have seen 15 and.
You have not challenged 13, 10, 20, 20.
I did not. What I
Then
say, my lord.
where is the question of
I submitted
reconsideration?
all of the documents.
Where
before
is
the
the
authority
question
itself.
of reconsideration?
But
Again, we are giving you opportunity from any document prior to 13, 10, 20, 20. You show that you have raised a plea that your mother was ineligible. Any document.
My lord, whatever document I had, my lord, I submitted with the
Please
authority.
show
Prior to 13/10/2020, any document or any
I
environment.
do not annex any
So
document.
that's not your case.
But I,
So once it is rejected, you make out a new case decades later as if you have right to this appointment.
no, it's not my,
What is this?
my respectful submission.
No, your conduct is very glaring.
No,
from the record.
I say that when, my lord, my application, they said that it is rejected belated.
All right.
And thereafter, my lord, I say
See,
that
you are
consider.
on 10AA or 10B you will rely.
Yes.
So you are claiming an exception because your mother is not.
Yes. But you,
So before 13/10/2020, you have stated this fact.
But it is the observation of the department itself.
It is not.
But page number 56.
13/10/2020.
But if you lodge
You consider page 56. Don't worry.
that is only the.
We are just trying to see the bona fide of your conduct.
But page 56, my lord, is the only document I could.
Then you have no case. That's all.
But
You may show us what you want to show. Give.
no, my lord, I was just only showing your lordship on a 10AA, which your lordship has already
We
said.
know. Yes, take down.
Your
Note 35.
I'm for the respondent, your
Note 35, I beg to appear on behalf of the appellant. Lord, in this matter, my lord, it is, my lord, item number 31, your lordship. My lord, we preferred an appeal. Your lordship has already passed an order, my lord, for.
And what is the order in this case?
My lord, in this case, my lord,
consideration of my representation where I'm wanting my terminal benefits or the pension.
let's see, where is the order? Let us, my lord, page 159. My lord, the relevant paragraph is, my lord, paragraph onwards. 8 onwards, lord. I'm sorry.
Internal page 2.
Internal page 2.
So you don't want to consider his claim?
Milord, the problem is, Milord, the order is silent about, Milord, the date. Milord, whether, Milord, the date, Milord, the admitted use, Milord, whether it is from the date of suspension.
This is what you are required to consider. If there was a finding, then we could understand that you have filed an appeal. When it is left to you why you have filed an appeal, that's what we are wondering.
Milord, only humble submission is nothing is admitted, seven except, Milord, the date of who?
Is there anything in the order that you have admitted to anything? Or a liability has been fastened with reference to any date or any. Why you have filed the appeal?
Milord, the difficulty, Milord, is, Milord, about the date only.
Where is it? Therefore, we are asking you, difficulty is in the mind of the authorities or it is there from the order?
Milord, in the order, Milord, there is no specific date.
Then, sir, what is it? Tell us.
Milord, I tell your lordship, Milord, what happened, Milord, in the year 2012, Milord, this
That is not relevant. What has been decided against you in the order? That is all we are asking you.
My lord.
If you try an appeal,
Milord, Milord, state for Milord, we, Milord, sought for an operation of orders, Milord.
No, what is the question of stay of operation of this order for consideration? You tell us.
Lordship, then kindly adjourns, Milord, this matter for 2 weeks, Milord. We'll just seek instruction. And
we have put a specific query to the learner. Let it come with that or no. It will dispose of this. Why should it be kept?
I'll just take instruction and come back.
See, if you succeed there, everything will go. If you don't succeed there, you will.
And only one thing, Milord, so far as, Milord, the date of dismissal. If, Milord, if you, Milord, we are under the impression, Milord, the learner signature should, Milord, would clarify, Milord, from the date of dismissal. Otherwise, Milord, Lordship knows
all these apprehensions in the mind of authorities we can understand.
But 36.
Here's some of the appeal.
Hey. Item 37.
This matter, I'm paying for the appellants in this matter, my lord.
The order impugned, my lord, is at page 177 of the paper book, my lord.
177.
My lord. My lord, this is, my lord, this is the order which was being asked when a stay of operation of the order of the petition was passed, my lord. My lord, this is a case, my lord, of the appellants, when, my lord, the petitioner and the private respondent, if I may just in a very short, my lord, if I may submit.
Corporation is before us.
Yes, madam. Yes, madam.
Arising out of a selection process.
Yes, madam. My selection is LPG or LPG. My LPG donation distribution.
Yes.
The situation is that according to the guidelines which is being framed by the three oil marketing companies, so we know the sure. Yes, madam. The bullshit specifies specifically exactly that let's cannot offer the same piece of land for the showroom. This is a guidelines which is being framed by three marketing companies. But this particular case what happened brothers and sisters did not have a but they are from the same family. Subsequent to that, what has happened is that they offer the same piece of land for the showroom. It's covered in service selection process, and therefore, according to the guidelines, has been cancelled. That means the company judgment.
The writ petitioner and private respondent, they are siblings.
And
they both applied for the same before they both offer, they both are required to be separate applicants. Can you please hear us for a second?
Yes, I apologize.
Please be kind to us for a few minutes.
I
Yes.
apologize.
So they have both applied for the same site, or they are applied for separate?
Same site.
So from the same site, they have applied and offered the same land. This is your.
Yes, madam.
And where is the bar?
Madam, the bar is in the regulations, madam. The regulation says, madam, the brochure says, madam, as madam has observed, madam, the brochure says that the same piece of land cannot be offered by the both the candidates. The Honorable Appeal Court is also observed, page 178, if I takes the document, madam. The Honorable Appeal Court is also observed in the same line.
This was issued.
Yes, madam.
They
had appealed in the single judge in the Honorable Appeal Court also. Thereafter, madam,
in this proceeding, have they ever appeared?
Yes, my lord. If I will kindly take my lord, page 177, they have appeared, respond number 1, my lord. And a conditional LOI, my lord, in the interregnum has been issued, my lord, to the my lord, authority concerned, third party, my lord.
Same piece of land, does it mean same property or the same dimension?
My lord, the same piece means exactly the same land. The schedule of a lease deed, as my lord appreciates, schedule of the lease deed, which was offered before the authority concerned, is the description of the land which is being offered to the oil marketing company at the time of selection, my lord.
So there may be a description that plot number X is being offered. Now that plot number X may comprise of 10 kattas.
Yes.
Both may be offering at different points. So will they be barred under such a circumstance?
My lord, that benefit has been given in the case of go down in this situation. But in the case of showroom, it was exactly the same land which has been offered before the oil marketing company.
The same,
yes, my lord.
The same location of the
same location, same land. If I am to be please, my lord.
In their absence. Ask him to come. Where is your counterpart? You contact him. Since they are already appearing, why should we issue a notice afresh?
Yes, my lord.
Just ask them to appear so we can consider it. The brochure and everything is there.
The brochure is there, page 33 and 34. My lord, kindly seize, my lord,
Page 33.
My lord, 33, my lord. My lord, this is the guidelines, page 33. If my lord kindly takes in the middle portion, the brochure commences, my lord, from from page 23. If my lord kindly takes page 23 is the brochure on unified guidelines for selection of LPG distributorships of 3 oil marketing companies, Indian Oil.
Yes, brochure, MDG, all are for common for all the
Yes, my lord.
OMCs. That
My lord, page 33, if my lord kindly takes. My lord, in the middle portion, if my lord kindly sees, my lord, the same piece of land for go down.
33.
Yes, my lord.
First quoted in the order.
Yes, my
We are
lord.
just
Yes, my lord. It's quoted in the Honorable Appeal Court's order also.
Which company is this? HPC.
Hindustan Petroleum.
There is none to represent the response.
Seven 38.
This is a group 9. This will not come before this court.
The since your lordship has the determination of intra-court appeal.
Hearing.
Hearing. This is not a hearing.
It is not a hearing. We realized later. Last day we didn't realize whether he wanted the
Number 39 and 40.
My lord, I appear for the appellant. Lordship, my lord, if your lordships recollect, there is an appeal by the Calcutta State Transport Corporation. The writ petition had made his submissions.
Yes.
But with regard to regularization.
Oh.
He had cited couple of, your lordship, go to your lordship's last order, it will be clear. Lifted. Sorry. Two more. Lordship, excuse me, I have slight bit of cough, so therefore. ये is the आपको देता हूँ तेरा कितना 15%.
Yes.
All right, I'll be very short. I'll just place one paragraph of the impugned order and take your lordship to the legal position. So kindly takes page 69, which is the impugned order. It starts from page 69. Dated 1st of March, 1st of August 2024. Now, this was the impugned order was based on a particular memorandum. I'll only take your lordship to that, but it kindly turns to page 72. The third paragraph. It is pertinent to mention herein that the relevant portion of the memo dated 3rd August 1979 of the Labour Department, and it has been quoted. I'll place it from here, though it's annexed. Casual and such other categories of workers who have been engaged in a perennial type of work for a continuous period of more than 3 years may be absorbed in the regular establishment on temporary basis. Remember, on the first day, I had made my submissions based on this, that they can be, if it is on a they can be absorbed on temporary basis in the regular establishment. This memorandum nowhere says they can be regularized. The learned single judge, my lord, subject to correction, proceeded on the basis of this, that this entitles them to regularization. ওইটা কত নম্বর পাতায় আছে বলতো? এই পেজটা 56. Now, my lord, your lordship will find this memorandum at page 56 of your lordship's papers. So all along, my lord, I am at the sake of repetition, the principle by this state government was that they can be, if you're working for these the criteria are fulfilled, you can be absorbed in a regular establishment, but as temporary. It was possibly misconstrued. Now, my lord, kindly takes only one line at page 56, which is the memorandum. Now, I'm sorry.
Just give us one.
Lodge, I'm Lodge.
So he was engaged on daily rated in December 2002.
No, they are working. They have not been disengaged. They work till their superannuation.
Yes, 21st March 21.
Now, this is one part. I'm sorry, my lord, this is the notification which is actually a precursor to this later on notifications of 240 days and 10 years continuous and all that. But now kindly see that page 56, the subject of the notification.
And this memo of 79 was still applicable?
No. Well, that is why inside the submission that it was the precursor. Now, my lord, I tell your lordship, before your lordship turns to page 56, as it has fallen from your lordship, well, separate, later on, several memorandums came up. Ultimately, it was that if you are working in this capacity and you fulfill 3 criteria, one is 240 days, 10 days as one as a cut-off date, then you will be working till 60 years. You will not be disengaged, but as temporary. And the emoluments were increased separately, enhanced. Now, can you see page
16/9/2011? There is
16/9/2011. I'm declaring your lordship, followed by
9008.
I'm declaring lordship. But 16/9/2011 followed by 2 others till 2024 or 25, wherein the reasons remain same. The emoluments were enhanced.
16/9/2011 9008. Then there is one 1007.
Lordship.
Enhancing the rate,
the emoluments,
improving the conditions,
and then thirdly another which is the last, improving them further.
Yes.
But the basic principle of attaining will not be disengaged till 60 years, but as a casual or temporary worker.
Giving some security of tenure and some benefits akin to regular.
Number one, why I am taking your lordships to page 56 is
so that was applicable to the corporation also.
each department, that was the finance department said, each department brought out their own circulars based on that, the matching orders.
On the record, is there anything that you have adopted that?
No, not, as of now, I do not have that. But my lord, possibly this may be subject to correction. My lord,
No,
maybe
if that has not been considered, then let it
Lord,
be.
it has not been considered. What has been considered is this.
We'll
the
go
page
by only
56.
what is on record.
Page 56. Now, my lord, kindly, this is one line on page 56, the notification. Notification is at page 56, I placed from the impugned order. Kindly see the subject. Principles to be followed in the matter of absorption of casual and such other categories of workers under the state government, not the parastatal, the corporation. Rightly, wrongly, even these had to be applied to the employees directly of the state government. Clause 3 of this notification has been applied.
So you file an opposition before the single judge?
Lord, I tell you, Lordship, what had transpired.
You did not take this
No,
ground.
I tell you, Lordship. The order was passed ex parte, if I can use that word, because we did not appear. Because, my lord, we did not appear, we filed an opposition. The learned lawyers that were appearing filed the opposition. But on some misconception, they served the opposition on the learned advocate who always usually appears normally for against the corporation upon they was not appearing in this instant matter. So when the matter was taken up, it was passed ex parte. An application for recalling was taken up, which was dismissed, saying the upholding this impugned order. So therefore, two appeals before your lordship. On the last occasion, my lordship has been pleased to condone the delay. But on a different footing altogether as far as this is concerned. Lordship has seen this. Number one, my restful submission is that come what may. Lordships are, I've come with the decisions. Lordships are absolutely aware of the legal position. Well, I've got the decision, Lordship once, I'll cite them. But Uma Devi is absolutely clear. Only exception is paragraph 53. Illegal and irregular. Well, may I hand it over to Lordships? Or if
Yes.
Lordships are aware, I will go to the next.
Yes, no, we can, every time we read it.
Or I will not trouble
Why not?
Lordships with something which is absolutely, but illegal and irregular. Now, paragraph 53, I'll just give the outline. Paragraph 53.
Irregular has further been delineated.
In Keshri. In
It has
Keshri.
further been delineated by saying that continuous 10 years without an order of the court, appointment in accordance with Article 14 and 16.
And it has to be a substantive post.
Against the sanction post.
I'm deployed. That is where I am. That is Keshri. Now, my lord, thereafter, Lordships, they were in the Puran Chand's judgment. My lord, Uma Devi was watered down.
But they are relying on recent judgments which say Uma Devi cannot be taken as a shield.
Well, I'll come to the absolutely latest judgment. Well, Puran Chand, Uma Devi was watered down. Comes the case of Dayanand, which in no uncertain terms says you cannot do this. Uma Devi is upheld. Well, kindly seize the last judgment of the Honorable Supreme. Maybe this is the latest. Well, this is passed in July. May I hand it over to Judge Shepketi? I'll only take your lordship through one paragraph. This was with regard to, goes from here, from regard to madrasas. My lord kindly takes one paragraph, paragraph 39, both, na? Both hai, ball?
You will not give me the ball.
Any.
Thank you very much.
The ball, both hai? My lord kindly takes paragraph 39, I'm sorry, paragraph 31, sub paragraph C and D. May I place it? Paragraph C, this is page 39. Ms. Acharya, representing the petitioner, had to concede that the norms, guidelines laying down the selection process were observed in complete breach. She, however, claimed that the petitioner's regularization in service on the decisions of Jaggo, which my learned friend has cited, and another Shukhendu Bhattacharya. Then, my lord, kindly sees clause D. We find no merit in such prayer. First, this is not relevant, the first part. The first, the petitioner has not claimed writ of regularization, the writ petition, grant of court skips this. Secondly, if your lordship says, secondly, the question of regularization in service does not arise in this case because of the nature of the breach that has occurred. The court in Jaggo and even in the most recent decision in Shukhendu might have taken a liberal view, but such views have to be read as confined to its own facts rather than laying down the law which is binding under Article 114 of the Constitution. State of Uma Devi and Dayanand are larger bench decisions of this court. The ratio laid down therein has neither been doubted nor diluted by any bench of co-equal strength. The principle of stare decisis and Article 141 of the Constitution leaves us with no choice. Article 141 commands and the law declared in Uma Devi and Dayanand binds all. ratio, if any, laid down in the said decisions of ranges of lesser strength is debatable and we are not persuaded to follow the same. Jaggu has been relied upon by my learned. So before I take your lordship to Dayanand, everything, this my respect submission is conclusive. And this is possibly delivered on very recent, because I don't think it's been reported as yet.
13/7.
Noted.
13/7/26, date of judgment.
I'm deeply obsessed. So, your lordships are well. I want something more, I can play, but I believe this is conclusive. That 79 is no longer in existence. जासना मेरी तो आगे लॉ पॉइंट देखिए Oh. And I'm sorry. Yes. Only thing that although as this is clear, the learned friend has cited Jaggo, bereft of paragraph 39C. Lord Jaggo was a case wherein the Lord regularization not in question, subject to correction. The question was where the agitation was with regard in the writ petition to sanction the post.
So rejection of sanction
posts
by the state government.
So therefore, my lord, the factual situation matrix was completely different. Now those are my submissions.
Yes. What I said, this point has not been clarified or he has not been said anything. What I say, the CSTC
Reply, you want to argue after reply also?
All right, well, if you
we have recorded all
what I
your
have not, what I've said before your lordship, he has not taken it.
that we have already recorded in the order, so there is no.
Because yes.
We have heard the learned advocate for. We have taken note of your submission. We will consider. 17. No, keep it on 24th. Oh, yes, that weekend will not be possible.
August. Lordship.
I have said he has not answered. I'm grateful to your lordship for kind of.
41. 41 for the petitioner. And this is our copy of the reply to the section 5 application. Yes, ma'am.
Where were you on 20th? It was taken up, none appears for the appellant. Why? You are filing a reply. You have served. Who is appearing?
Mr. Achin Mojumdar is appearing, ma'am. reply is being filed by the learned advocate.
The 42.
Case of compulsory retirement along with benefits.
Everything was there, Lordship. There's
Along with benefits.
Yes, Lord.
Lesser benefit.
Huh?
Lesser benefit.
No, we are just trying to we are not
Premature
indicating.
retirement.
Huh?
This is premature retirement.
Premature.
Right.
Yes. This
That's premature retirement, Lordship.
pursuant to a proceeding, after proceeding.
No.
Simpliciter.
No.
Simpliciter.
Simplicity, Lordship.
No stigma.
No stigma. Stigma, Lordship. We have taken the entire ACR because Lordship knows that premature retirement or compulsory retirement does not tantamount to any punishment. The Honorable Supreme Court has said in many years this.
No, so
whenever
if you are claiming the action was taken to remove deadwood,
that is.
then what is the form of the order that we are asking you?
My lords,
Does it have any stigma?
I shall place it before my lords. It has certain stigma because he has received a lot of punishments. There have been reports against him. And subsequently thereto, he was not given any promotion in the last 5 years. It was the benefit of MACP which he received, which in my understanding, the Honorable Single Judge misconstrued to be promotion within a period of 5 years. Because Lordship, if my Lord kindly allows me to place my Lord's nose, that if the promotion on the base of merit is given within 5 years, and he has been found to be fit, efficient, then this compulsory retirement or deadwood case needs to be dealt with in a proper manner. But otherwise, if their entire ACR taken into consideration, a prudent man can come to a conclusion that there are certain censure, there are certain records which shows that he has been delinquent in his duties, he has not performed it, but then he was getting his MSCP benefits because of the service. Lordship, I am only on, Lordship, if my Lord allows me, I will not take much of my Lord's time. I myself, my Lord, I will just try to place what the Honorable Single Judge has taken into consideration 56J, read with section 40, rule 48, FRA full form fundamental rules 56J, Lordship 48 of CCS pension rules, and then Lordship broad criteria. And Lordship, the broad criteria which are to be taken into consideration while treating him as a deadwood. Now, Lordship, may I take your Lordship through the judgment? My contention, my limbs of submission are threefold before your Lordship. One, whether this type of retirement tantamounts to a punishment, one, whether the entire ACR is to be considered, and last but not the least, if MSCP can be construed to be a promotion. These are the basic salient points of my argument. If my Lords kindly allows me to press the impugned order. Now, the impugned order is dated, judgment is dated 2nd of September 2022. Now, Lordship, I'll not trouble your Lordship, but my Lords, I will try to take your Lordships at page 2, paragraph 3. By order dated 14th June 2016, the Deputy Inspector General CISF North Eastern Zone prematurely retired the petitioner from services. The petitioner further stated claimed absence of provision of the appeal against the said order of premature retirement compelled him to submit a representation dated 28 June 2016 before the Director General on the grounds as raised therein. By order dated 10th of October 2016, it was communicated the representation submitted by the petitioner has been rejected, stating the Deputy Inspector General CISF headquarters was of opinion that it was in the public interest and in exercise of powers conferred by fundamental rules and central civil services pension rules 1972, the petitioner was retired from service and he had already completed 50 years of service. The petitioner further stated that as per rule, the matter of premature retirement should be decided by the board presided over by the head of the department. The head of the department was the Director General, and the Deputy Inspector General was much inferior in the rank that the Director General. Therefore, the impugned order of premature retirement has been passed by the authority devoid of jurisdiction. The respondent had passed the order of premature retirement due to extraneous reasons, considering the petitioner to have become a deadwood in absence of plausibility. His past 5 years grading in the ACR was either very good and outstanding, and therefore the order of premature retirement had passed arbitrarily without application of mind. Apart from the ACR for the past 5 years, the ACR grading from the year 2006 to 2015 were either very good or outstanding. In the rule, there is a direction only to consider the ACR and not the past penalties, whereas the instant case, the respondent have been considered. Respondents have also considered the past penalties inflicted before and after promotion. The concerned respondent failed to appreciate in its proper perspective that the petitioner have been awarded in cash for 23 times. The learned advocate representing the petitioner submitted the order of premature retirement to have been issued mechanically, contrary to the mandate of law, considering the petitioner to have been a deadwood, devoid of constructive contribution in the service, voluntary compulsory retirement, in contravention with the provisions of clause 1B of Rule 48. The order of compulsory retirement, premature retirement, was issued by the review board, which lacked jurisdiction, as the same was not presided over by the head of the department, being the statutory requirement. The petitioner has been granted 23 instances of cash rewards for commendable and grading of very good / outstanding for the year 2006 to 2015, which demonstrated his active participation, adaptness, skill, vigor in discharging the duties, and such a nomenclature of being deadwood has been biased, arbitrary, and irrational. Moreover, the competent authority did not lodge doubtful integrity tainted by extraneous circumstances. The petitioner accordingly should not have been given compulsory retirement. The petitioner prays for the writ. Now, Lordship, the submission which was made on behalf of the respondents. Learned advocate representing the respondent authority submitted in compliance of fundamental rules. I'm going on another matter. It was financial rules. Everything is getting juxtaposed. Fundamental rules, Lordship. 56J, Rule 41AB of CCS pension rules. The entire service record of the petitioner was taken into consideration prior to the conclusive determination of affording compulsory retirement in his favor, which had not been a punitive action to the detriment, obliterating arbitrariness, malafide intention, and biasness on the part of the respondent authority. 23 instances of cash reward, ACR grading of good, very good, outstanding for the year 2006 to 15, grants of MSEP benefits could not prevail over the undermine his grave misconduct, dereliction of duties, high-handedness, and adverse entries in his service records, imposing 2 major and 5 minor punishments for serious misconduct, namely theft of plant property while on duty, misconduct and indiscipline during parliamentary elections 2014, absence from duty, quarreling and creating public disorder, unauthorized use of unit vehicles leading to a fatal accident of CISF personnel's negligence in handling duty of injured constable, continuous failure to sign suspension register. The statement of superannuation review under 56J oblique CCS pension rules 1972 in respect of Group B, non-gazetted officers dated so-and-so inter alia states this. Now, Lordship, I will flip over these pages. Then I will come to the major 2 Lordships, the punishments which were given to him. That is at page 5. Now, Lordships, কোনটা না মাইনার 2 আছে এটা কোনটা now at page 6 Lordship it will be minor at page 6 minor 2 may be considered as minor 5 Lordship. Now, these were his service ACR record, which were taken into consideration also, apart from good, very good, and the money which he was given. Now, Lordship will kindly allow me to place paragraph 11. The relevant fundamental rules issued by the Ministry of Personnel, Public Grievance and Pension Department of Personnel and Training Establishment, so-and-so, dated so-and-so, replicates as under. Office Memorandum, Lordship, I'm skipping this. Then, Lordship, I am intending to place fundamental rule 56J, which have been reproduced in the
according to minor 2 is wrong.
Minor 2 is minor 5 it will be. Minor 5 those are the punishments which were given to him. Now, Lordship will kindly, now I am coming to whether, Lordship, 2 aspects. What we are well within our right to do this, and whether there was any arbitrariness, biasness, or error apparent by the review committee on ascertaining his SCR, considering them, and then coming to a conclusion. Now, Lordship will kindly appreciate.
There is a finding of the committee that he is to be
review committee has review committee has আমি জানি page আমি জানি আমি বলছি ওইখানে বলে review committee. Lordship review committee. I'll place that, but just because I don't want to place the entire records, because since I am challenging the impugned judgment, Lordship, I am just trying to point out where, I am under the impression, Lordship, my understanding of the subject is that the Honorable single judge went wrong, or rather, Lordship, her ladyship misconstrued the judgments which are holding the field, and also the interpretation, Lordship. Fundamental Rules 56J. Now, Lordship, the appropriate authorities shall, if it is of opinion that it is in public interest so to do, have the absolute right to retire any government servant by giving him notice of not less than 3 months in writing or 3 months pay and allowance in lieu of such notice. If he is a group A or a group B, the respondent happens to be a group B officer, service or post in the substantive quasi-permanent or temporary capacity and had entered government service before attaining the age of 35 years, after he has attained the age of 50 years. So these qualifications are all there. Then Lordship will allow me to come to CCS pension rules 48, which has been again verbatimly reproduced in this page, which says rule 48. At any time after the government servant has completed 30 years qualifying service, he may be required by the appointing authorities to retire in the public interest, and in the case of such retirement, the government servant shall be entitled to a retiring pension, provided that the appointing authority may also give him a notice in writing to a government servant at least 3 months before the date of which he is required to retire in the public interest, or 3 months pay and allowance in lieu of such notice. Now, Lordship, this also has been done. There has been no folly over there. Now, my lords will kindly allow me to take my lords to the next page. If my lords allows me to place the last paragraph of page 8. My lords have got Roman 4. No government servant should ordinarily be retired. Here, my lords, there was a doubt in the mind of the Honorable Single Judge, where I am trying to impress about what went wrong. The government servant should ordinarily be retired on the ground of ineffectiveness if his service during the preceding 5 years, or where he has been promoted to a higher post during that 5-year period, his service in the highest post has been found satisfactory. There is no such stipulation, however, where the government servant is to be retired on the ground of doubtful integrity. In case of those government servants who have been promoted during the last 5 years, the previous entries in the ACR may be taken into account if he was promoted on the basis of seniority, cum fitness, and not the basis of merit. Now, Lordship, next, the entire service record of the government servant should be considered at the time of review. The expression service record refers to all relevant records, and therefore the review should not be confined to the consideration of the ACR/APAR dossier. The personal file of the government servant may contain valuable material. Similarly, his work and performance could also be assessed by looking into the files dealt with by him, or in any proper paper or reports prepared and submitted by him. It would be useful if the ministry, one department/cadre, puts together all the data available about the government servant and prepares a comprehensive brief for consideration by the review committee. Even uncommunicated remarks in the ACRs/APAR may be taken into considerations. Now, Lordship, there were judgments which were cited by us, which I would take. Now, Lordship, before going to that, now, my lords, I will intend to take your lordships to paragraph 20, which is at page 17. My lord, all those judgments, I will again place it before my lords, as to which say specifically that if there is no arbitrariness. Now, Lordship will kindly allow me to place paragraph 20. The fundamental rule FR 56J and rule 48C pension rules, as stated above, categorically mention the government servants whose integrity has been doubtful should be retired. The ones found to be ineffectively should be retired. The basic consideration in identifying such government servant should be their fitness/competence to continue in the post. The ACR grading of the present petitioner since the year 2011, marked in annexure page 15 to 49, has reflected performance to be good, reasonable, prompt, punctual, efficient, hardworking, devoted, reliable, physical, in good measures, in industrious, laborious, so on and so on. With the management possessing good knowledge relating to OM and other administrative duties, sincere, good liaison with management and other agencies, ability to motivate his subordinates and team, state of health, shape 1, integrity, beyond doubt, etc. The ACR grading has been endorsed by superior authorities prior to the reporting officer. Now, Lordship will kindly turn to the next page, and my lords will kindly come to paragraph 22. The review committee did not determine sudden and steep fall in the competency, efficiency and effectiveness of the petitioner to compel him to retire, otherwise being malefic to public interest. Broad criteria to be followed by the review committee, as aforesaid, categorically stipulated that the government servant should not be ordinarily retired on the ground of ineffectiveness if his service during the preceding 5 years, or where he has been promoted to a higher post during 5 years, his service in the highest post has been found satisfactory. Now, Lordship, to the Honorable Single Judge is basing that in the last 5 years, he was given promotion and his ACR gradings are par excellent. So, ACR grading par excellent coupled up with his promotion for the last 5 years goes to show that he is not a deadwood, or for public interest, his services cannot be given a go-by, or rather premature retirement should not be given. Now, Lordship, I will try to impress very humbly before my lords that that is a wrong finding on facts, because, Lordship, the first point which I am trying to very humbly submit before my lords is that, my lords, ACRs do not show that he has a pristine service career, because as already placed that he was given punishment as has been stipulated in the order which I tried to take, my lords. Apart from that, Lordships, if my lords, the promotion is concerned, my lord, he was not given any promotion from 2001 onwards. The gentleman was the recipient of MACP, which does not tantamount to promotion. It's a financial benefit, my lords knows. And that cannot be said to that promotion was given to him within 5 years. Now, my lords will kindly see the next paragraph, that is paragraph 23. The petitioner, as per service records concerning the ACR grading, the cash rewards credited to him, the benefits of MACP conferred on him did not constitute ineffectiveness, dishonesty, incompetence, lack of fitness, or agility to perform his duties. The major and minor penalties cited to be the reason of compulsory retirement thrust upon the petitioner had been unconscionably in disguise of the same against the public interest, since the authority concerned to whom the petitioner reported and the superior authorities had condemnably embellished his performance exemplarily. The respondent authority did not institute any disciplinary proceeding against the petitioner and cannot compulsorily or prematurely retire him from the service in the garb of being a deadwood, granting promotion to the petitioner, disregarding the punishments imposed on him in view of the decision of the Honorable Supreme Court as cited and acted in his favor. Now, Lordship, as far as Honorable Supreme Court is, I will cite it, my lord. That does not come to the rescue of the respondent. Be that as it may, the error, Lordship, in the finding is, my lords will kindly appreciate, first of all, the finding that there was no penalty cited against him in this. The penalty was given against him, and Lordship will kindly see when the Honorable Single Judge has come to this finding, since the authorities concerns of the reported and superior authorities condemning embellishment, Lordship, the major and minor penalties as cited to be the reasons of compulsory retirement thrust upon the petitioner had been unconsciously in the disguise of the same, being against the public interest, since the authority concerned to whom the petitioner reported and the superior authorities condemnably embellished his performance exemplary. The respondent authority did not institute any disciplinary Lordship, all those were proceedings only, where he was given punishments. Those were disciplinary proceeding. How the Honorable Single Judge comes to this finding, a question I am asking myself. And he did not challenge those punishments. Then, Lordship, coming to the next aspect, that he cannot be declared to be a deadwood because he was given promotion. It's a wrong finding on facts, my lords, because of the reason that, my lord, he was not granted any punishment. He was not granted any promotion. MSCP cannot be construed to be promotion. Now, Lordship, for that fact of the matter, Lordship, I will beseech your Lordships to take the CAN 2 application. That is our stay application. And Lordship will kindly come to the review order, which starts at page 66. Finding of the review committee. Lordships have got it?
10, 10, 16.
Lordships. Now, will allow me to read paragraph 3 and its subparagraph 1. On scrutiny of service records of so-and-so, the representation committee observed that during his entire service, he has been awarded with 2 major and 5 minor punishments for various acts of serious misconducts, like involving in the theft of plant property. Now, Lordship, the finding of the Honorable Single Judge that his career was impeccable is not correct. While on duty in KSTPP Korba, not allowing other COI personals from using bathroom by locking it, inciting personnel of one COI to assault personnel of other, and using derogatory language while on election duty in General Parliamentary Election 2014 in Meerut, Uttar Pradesh. Third, remaining absent from duty, quarreling with colleague, and creating ugly scene in front of residents of VSSC, Tumba housing colony, taking unit vehicle to Bareilly while posted in IFCO, Onia, without permission, which met with an accident en route resulting in death of 2 CISF personnels. Now, Lordship will kindly recapitulate the paragraph of the judgments which I have placed before my lords, that no disciplinary proceeding and he had an impeccable career. My lords will say that that is a wrong finding on facts. Resulted in death of 2 CISF personnels, not taking prompt action on seriously injured late constable Bhagiram Yadav while performing duty as reserve inspector, OTT, failing to sign suspension registers. Out of these, 7 punishments awarded to him for various acts of negligence and misdemeanor. On one occasion, he was not allowing prisoners of other COI from using bathroom by locking it, inciting personnel of the COI to assault personnel of other, and using derogatory language while on election duty on so and so. It's a repetition. Lordship, it's a repetition, I suppose. Then Lordship will kindly. On another occasion, he was punished for quarreling with the colleagues and created ugly scene in front of a family quarter. The representation committee further observed that he was promoted to the rank of Inspector Executive in 2001. Now, Lordship, here I am pausing for a moment. He was only given proper promotion in 2001. But even after promotion, The individual failed to improve his conduct and has since been awarded with 1 major and 3 minor punishments. This reflects his casual approach towards bona fide government duties. His repeated indulgence in acts of indiscipline, even after being promoted to inspector executive, shows his lack of commitment to his duties and is not amenable to the high degree of discipline expected from the member of a disciplined armed force of the Union, that is CISF. During the last 10 years of service, he has been awarded with 1 major and 2 minor punishments. The representative committee has also observed that during his entire service, in his annual confidential report, he has been graded below average once and average on 2 occasions. He has pleaded that to consider his 23 cash rewards, APAR grading, and MSCP benefits. However, his grave misconduct mentioned in paragraph 3 above is also cannot be overlooked. It is relevant that he has been awarded 7 punishments in his entire service, including 4 penalties, 51 major and 5 major, 1 major and 3 minors, awarded in the rank of inspector, serious misconduct. In view of the above, and after consideration of the entire service records, the representative committee has come to a conclusion that the petitioner is not amenable to the standard of discipline expected from an enrolled member of the force, and continuation in armed force of the Union like CISF is not in public interest. Thus, the representative committee does not deem fit to interfere with the decision of superannuation review committee to retire him prematurely on attaining 50 years of age under the provisions of Fundamental Rules 56J. Hence, the representation submitted by so and so is considered and rejected, being devoid of merit. So, Lordship, what I am trying to cull out from this particular order, that it is not that he did not face any discipline proceeding. It is not that he was not given any punishment. And in light of all these punishments, when he has attained the age of 50, we gave him premature retirement, which we can do it well within our rights under under Fundamental Rules 15J. Now, Lordship, the finding of the Honorable Single Judge, again coming back to that he had been given promotion at paragraph 23 is not factually correct, because Lordship will kindly appreciate that MSCP enhancement does not tantamount to promotion. And Lordships will kindly once again allow me to place, which I had placed before this, those paragraphs of the judgment where the Honorable Single Judge has categorically stated or verbatimly reproduced 56J, which is at page 7. Lordship, we were well within our right to exercise the provisions of Fundamental Rule 56(1), and there is no anomaly or arbitrariness in this. Then again 48(1), and Lordship will kindly allow me to once again place at page 8, the last paragraph, that the entire ACR is to be taken into consideration, 4 and 5. So when the entire ACR is taken into consideration, and he was not given promotion in the last 5 years, because admittedly the last promotion which he was given was as inspector executive, and the premature retirement is also given to him while being in that post. Now, Lordships, now my lords will kindly allow me. So, my lord, if my lord again takes into consideration page 8, Roman 4, that last paragraph of page 8, and page 9, Roman 5, my lords will kindly appreciate that we have taken into consideration the entire records, and after that we have come to this conclusion where there is no arbitrariness. Now, my lords, again coming back to the portion of judgments which I was placing, as my lords, I have placed paragraph 23 at page 18, and then Lord's page 19, imposed him in view of the decision. Now, Lordship, I'm coming to paragraph 24, Lordships. The petitioner could have contributed his service to the respondent authority if not compulsorily ordered to retire prematurely to weed him out possibly. In view of the intents and purpose of the rule as stated above, the decision of the Honorable Supreme Court, the order dated 14/6/2016, whereby the petitioner was compulsorily retired, is quashed. The court deals with the ground based in which the review committee prematurely retired the petitioner without assessing the constituents of the same. The case of the petitioner should be considered by the appropriate review committee constituting for assessment in case of non-gazetted officers so and so. The petitioner is to be reinstated with back wages if he is yet to attain the age of superannuation. If the petitioner has already attained the age of superannuation, the arrears of salaries and allowance to which the petitioner is entitled to be disbursed in his favor, along with retirement benefits with the interest of 6% per annum. Now, Lordships, so the long and short of the judgment of the Honorable Single Judge is, Lordship, that 5 years, in the last 5 years, he was given promotion, which is incorrect. Secondly, Lordship, MSCP cannot be considered as promotion. Third, my lord, their premature retirement is not a punishment. And if there is no arbitrariness in the order, the jurisdiction of this honorable court is limited. That is what, Lordship, I will amplify upon by certain judgments, my lord, which I may place before your Lordship on the next day, if my lord so allows.
Yes.
Because this, my lord, not judgments, my lord, the Honorable Supreme Court's judgment with the Honorable Single Judge is relying upon, my lord, that does not, my lord, lay down that principle.
You must have filed an opposition in the writ proceeding.
Opposition to data Shomai Daim. Opposition, part of it. Lord, I apologize, my lord, I was not before the Honorable. देखे ना और मोने होए ना
70. You have placed anything to show a consideration?
Yes, Lordship. Our opposition is at page 70 of my Lord's brief.
What material you have placed?
My Lords will kindly allow me to place page 72.
You also filed a supplementary.
Lord, at page 72, my Lords.
Opposition and supplementary also filed at page 80.
Yes, Lords. Page 80, Lords. Page 80 now.
See, in paragraph 8 of his writ petition, he has made a specific averment. Sorry, paragraph 9. That it was required to be considered by a board. Where is that answer to that query?
Paragraph 8 and 9.
Paragraph 9 of the writ petition.
Lordship.
Was required to be considered by a board headed by the head of the department, according to him, the Director General. What have you said?
You
have not said anything. Matters of record, that is your claim. Eight to 7 you have answered.
I have said the matters of record, 7 except what are matters of record we deny.
So he has.
Now, Lordship will kindly come to. Page अरे भाई पेज বলছি তুমি সাপ্লিমেন্টারি এমন তো পেজিনেশন করা হয়েছে 10টা পেজ চলে আসছে kindly bear me 79 the affidavit in opposition where is your supplementary my lords will kindly come to page 80 annexure P3 my lord will kindly come to page 81 we have categorically my lord stated my lord kindly allows me to place paragraph 3 paragraph 4 my lord 3 onwards lord P to 8 lordship
You have the FR with you.
my lords
You have FR with you.
fundamental FR also forms part of my lord's brief দাঁড়ান আমি দেখছি rules position
This is considered by a review committee.
yes lordship FR is at
No, which committee takes up the issue to consider whether a person is to be retired or not? What is the name of that committee? Constituted under which provision? He has said it is to be by a committee presided by the head of the department. You have in your opposition, you have not dealt with this.
my lord but we have in supplementary affidavit categorically stated that
What?
my lords will kindly allow me to place
Please come to paragraph 8 of your supplementary affidavit.
my lord will kindly page lordship.
Paragraph 8 of your supplementary affidavit, page 83. What does that mean? You are giving us a composition. He is raising an objection. It was not considered by that body. You are saying this is the composition.
my lord will allow me to place it then lordship we have stated that we have actually it is not that happily worded the supplementary affidavit but my lord kindly takes up paragraph 8 that is at page 83 we have said I humbly submit that the constitution of the review committee shall be as per appendix 5 of rule 56 so and so it should have a was but it has been shall be that's a wrong grammatical in relation to the instructions regarding premature retirement of government servants in the instant case the powers vested in the appropriate authority are exercised fairly and impartially and not arbitrarily so lordship we have said that the rules and the way it has to be performed that was done
You also produce the deliberations of the review committee.
Deliberations of the review committee.
Have you produced?
May I, what is falling from my lords? I have more or less noted those, sir. So, my lord, may I come back with specific answers to whatever queries have fallen from your lordships?
No, we have no queries. This is good. Whatever you have said is enough. With hearing.
No, lordship.
We'll see your judgments and then.
My lord, will kindly allow me one more day. I will come with judgments and whatever has fallen, my lord, because that intrigueness will be in my mind. Because what has fallen from your lordships, being my lord's officer,
So see, there are basically 2-3 things.
Yes,
He
because
has-
whenever something falls, my lord, we can understand that what is
There
crossing
are
Lordship's mind.
altogether 5 objections raised by him in the writ petition. So the first is head of the department. Second is only 5 years was to be considered. Third is past penalty cannot be considered. And then contravention of Rule 1B, Clause 1B of Rule 48. And the last is that entire service record, whether it was taken into consideration under Rule 56J. So these 5, there appears to be 5 objections raised by him before the learned single judge. Just now I have marked it, going through the judgment when you were reading it. But in your opposition, we don't find any response to these issues. There is no denial and there can be no denial that you have the jurisdiction, you have the authority to do it. But the authority is never unbridled. It is guided by certain considerations. He has raised specific issues. We don't find any answer in the opposition. Therefore, we ask him. Whatever is on record, we cannot travel beyond that. So let us see.
Well, I will try to amplify on these points. My lord, the constitution of the committee, that is a matter of record, which we have put by a way of a supplementary after one. That will also could be deciphered when my lords will see the review committee's order, which I had placed. Now, lordship, whether the entire ACR is to be considered or not, that is a part of the fundamental rules, which categorically says that yes, it is the entire ACR. And powers are unbridled because, lordship, because the Honorable Supreme Court as well as the coordinate bench of this Honorable Court, in another judgment, pat on the point, has come to certain blatant findings. One, which I will place, that it is not a punitive measure. Secondly, then, my lord, MACP cannot be considered as a promotion, which will act as a shield or a vigil to you being prematurely retired and taking into consideration that since you were given that MSCP, you were fit for service and you haven't. And then if you do not have an impeccable past, so my lord, that aspect.
Provisions of MSCP was also considered.
Yes, my lord, everything.
The provisions of MSCP has been.
MSCP, my lord, in my respectful submission, my lord, if a person is serving for a considerable period of time, MSCP concept, lordship knows, Millards, it is that because of his service, he is entitled to certain benefits. But that does not tantamount vis-a-vis, because Millard, what the Honorable Single Judge has said. Honorable Single Judge said.
MSCP is not a substitute for promotion.
Lordships.
It is to remove the stagnation.
Lordship.
But the ACP, MSCP always has a provision laying down the qualification, essential prerequisites for grant of such a benefit. Otherwise, the person is required to be fit for a promotion.
Lordship.
Then only he is granted the benefit of ACP and MSCP. If he is not fit, then normally the rules do not contemplate grant of such a benefit.
My lord,
therefore, MSCP. Therefore, we are asking you: was the MSCP considered?
It was considered, in my understanding, because I have gone threadbare. And, my lord, apart from that, my lord, the Rule 10, which I was placing, says that promotion, as far as premature retirement is concerned, it should not be on the basis of seniority. For 5 years, that seniority is not that. It is the promotion which is basically, Lordship will kindly, the promotion which is to be taken into consideration for this purpose, that you cannot exercise your powers, is, Lordship. My lord will kindly bear me. If he is promoted on the basis of seniority come fitness and not on the basis of merit, if he is promoted on the merit of on the basis of merit, then, my lord, that merit would stand as a stumbling block from giving him premature retirement.
No, we are not.
But any other promotion.
Here, there is no promotion to begin with. According to you, there is no promotion.
Lordship.
Therefore, whether it is merit come seniority or seniority come merit, that hardly matters.
Lordship.
Your case is there is no promotion.
Lordship.
So, whether an MFCP granted to him in 2008 The second benefit was granted in 2008, perhaps, as I could see from the record.
Lordship.
So whether having given such a benefit, anything prior thereto could have been taken into consideration.
Lordship, I shall come back to my lords.
We are just thinking out loud so that you may be able to.
My lord, yes, my lord, because it's my duty, my lord, and if something falls from my lord, things become easier for me. Otherwise, my lord.
For further sub